Here's for listing. Please give it to the court master. He'll have to make adjustments. Yes.
Wait, no.
Yes.
I did to mention item number 61, my supplementary list. That is wrongly listed.
Item 61.
61. Speaks on next.
It's a Kanta matter.
Yes, ma'am.
Wrongly listed today.
Yes, ma'am. It speaks on Monday, madam. 20.
Okay. Both sides are represented. Mr. N.J. Khatuniyar, Learned Counsel for respondent numbers 1 to 4, has submitted that this matter was otherwise fixed on Monday is a holiday. It could not be Monday.
20 minutes.
Oh, achha, the next Monday. Okay, 20/11/2023. According to list, the matter on 20/11/2023.
Item number 1. Item number 1, Your Lordship, the councils from Delhi want to move this case before Your Lordship. It may be taken up in the first week of December. 4th or 5th December.
You could ask for video conferencing and have it done. You want an adjournment today? This is an arbitration matter. Yesterday, issue has arisen, so therefore you'll have to address us on 2 points. On the prayer made by Mr. A. Sancheti, Learned Counsel for the petitioner, the matter stands adjourned today. Elementary education was there. Mr. P. Borak, Standing Counsel for Elementary Education, and SSA is and Mr. P. Nayak, Learned Standing Counsel for SSA are present. Next para. On the next date, the Learned Counsel for the petitioner shall address the court on whether the affidavit filed in support of the petition is in conformity with clause 2 within bracket small h of the that I got of the appointment of arbitrators by the Chief Justice of Guwahati High Court scheme, 1996. List on
The first week of December.
December 6th December. Okay.
May I please?
Yes.
I on behalf of Mr. S. Kora, Standing Counsel PCB Lordship, please to mention item number 37 Lordship. But if due to some personal difficulty, he is not available to the court Lordship, and he has taken the consent of other side Lordship.
37.
37.
Okay.
Mr. S. Kora is the Standing Counsel of PCB Lordship.
Okay.
He has taken the consent of
Okay.
other side.
Okay. Both sides are duly represented. On the prayer made by made on behalf of Mr. S. Barwa, Standing Counsel for Pollution Control Board, the matter stands adjourned today. List after
2 weeks.
2 weeks. Any interim order is there? Okay. Give a date after 2 weeks. Yes.
I beg to mention item number 4.
Item
40.
40.
In this matter, my lord, the earlier incumbents are replaced by some new incumbent, my lord. Therefore, I want to impeach it.
Okay. On the prayer made by Mr.
M. Sajjana.
M.
Okay.
Saikia, counsel for the petitioner, the matter stands adjourned today. List after?
1 week.
List after a week. Okay.
I beg to mention item number 15, my lord.
15.
Yes, I am taking the consent to the other side. In this case, I am not a reply to the opposition side. So may I play this matter will take on the next week along with this affidavit.
Okay. List after a week. On the prayer made by Mr. G. Alam, counsel for the petitioner, so as to enable him to file affidavit in reply in the matter. So I've said to enable him to file. Okay. Okay, interim order stands extended to the next date of listing. Yes,
2% from the other side, the equation item number 31.
31. 31. Password for the day is paid for by the learned counsel for the petitioner. Okay.
Please, I beg to mention item number 41.
41.
For substituting number main income and matter, which time may be required.
Okay. On the prayer made by Mr.
SP Gwala,
HP Gwala, counsel for the petitioner. Matter stands adjourned today. List after
2 weeks.
2 weeks.
Please, Lordship. Lordship, with the consent of the other party, I beg to mention item number 24 on the daily list.
24.
And Lord, just adjourn the matter.
I am for the petitioner, but I have an urgency in this matter, so Lordship kindly take up this matter next week.
List on 22/11/2023 as paid for by learned counsel for the petitioner. Wait, 20. No, prayer was for by
Respondent number 6.
respondent 6. Okay, respondent number 6.
So item number 3, Lordship, I want to withdraw and I did again, like, most of my press. Item number 3, Lordship, I want to withdraw and specify again.
Okay. In fact, good.
Yes,
Good that you have done. Huh? Yes, okay. On the prayer made by Mr. BP Bora, counsel for the petitioner, is permitted to withdraw this writ petition and file and approach the court again,
Yes, that's why
if so
I
advised.
this point. I noticed this while reading it, but I noticed the mistake.
It's okay. Forest, who is there? Mr. KP Pathak, standing counsel for Forest Department, is present. Okay. But Mrs. Pathak, although he's withdrawing it and coming again, why didn't you ask your authorities the application, if it is there, you have to consider unnecessary burdening the what you call citizen with a litigation. Is it not unnecessary?
Whatever orders are passed, we'll at least have to consider it.
There's some error in that application.
Yes.
You condone those small issues.
And it's not.
Do it. Why Mr. Bora should come again? Okay. I'm not saying anything in the order, but I'm conveying it to him.
With the consent of the respective parties along with the district matter, I beg to mention item number 13 and 14 matter.
13 and 14.
What's the matter may counter next matter? There's some personal difficulty.
You're taking consent?
Yes, matter.
Okay. You're for?
I'm for the applicant matter.
For the applicant. Okay. On the prayer made by Mr. DJ Medi, counsel for the applicant, matter stands adjourned today. List after 2 weeks. 13, 14. Okay. Interim order passed today stands in the writ petition stands extended till the next date of listing. Okay.
Yeah, please. Another mention item number 35, madam.
35.
Yes, it was relating to the release of the vehicle, but in the meantime, madam, pendency of the case, they have issued a provisional release order.
Okay. Mr. J.I. Barmia, counsel for the petitioner, submits that the petitioner has got an interim relief from the authorities and therefore has instructions not to press the matter. Accordingly, with liberty to the petitioner to approach again, the matter stands dismissed on withdrawal.
Sir, Lordship.
Yes,
Lordship, I agree to mention for listing of one writ petition.
listing, give it to the court master.
Supply item 48 for delivery of order.
This replacement stands dismissed. Because on that day I could not deliver the order, so that's why we get it listed here. Just go through it.
Okay.
Supplementary item 58 and 69 upgraded.
But Mrs. Burman, I think you have to, at your end as a senior government, additional senior government advocate,
Yes, sir.
I think you'll have to call a meeting with the departments. Especially having a meeting with the chief secretary. These issues of what you call compassionate appointment, you'll have to take a relook. The amount of litigation which is coming up.
Already, Lordship, since 2017, Lordship, the compassionate.
No,
appointment-
but you
that
see
is
17, 18, whatever.
Yes, sir.
But you are looking at the number of litigations which are coming into the court. So is it not the duty of the state to just take a call? Compassionate appointment, and people are coming from 2009, 10, 11, 12. And we are bothered with,
Lordship, Secretary has issued a notification, Lordship, that since the compassionate appointment stream is closed, Lordship, that the
you
whole
give us
pending-
those circulars, and in one case we'll draw up a suo motu contempt. If they're not following not contempt,
Only
we'll direct the state government in an appropriate case to take action against all those persons who are not complying with the direction of this of the chief secretary.
that the only those cases which are pending, Lordship, without consideration, that case may be. placed
No,
before
but you
the
see, but
SMC
you
or
you're
PFC,
looking,
Lordship.
you see, we are
That's
dismissing the
notification.
we're dismissing these matters, and it pains us.
Yes, Lordship. But after that notification, Lordship, that so many cases are, Lordship.
No,
pending.
but why? You should, is it not necessary that you should take a call why citizens are coming to court?
Yes, Lordship.
Then have a meeting called.
Yes.
Because unnecessary, you see, it's painful exercise to dismiss the petition of compassionate appointment. People have no source, no succor. They come to court. We dismiss it on small issues. But that compassion is still there. We are not heartless.
Yes, sir. All right.
If you take a decision and then you give us that copies to us, in one appropriate case, we'll direct the state government to draw up departmental proceeding against those officers who are not complying with the direction of chief secretary. If the chief secretary is not bothered with the thumbs shown by the junior officers, then what you call in English, we have a what you call prayer, God save the world. Chief secretary issues a circular, nobody bothers.
Only the pending cases, Lordship. that is-
No, I
that is
understand,
not
but you are
for
looking
last-
at the number of litigations. Every day we are looking at about 10 cases in a day for compassionate appointment. So either your officers are what you call ardent followers of that, what is that cold drink? What is that? So they are followers of that. They don't bother of the chief secretary, they don't bother.
These cases are old case, Lordship, there are, Lordship,
You see, I'm not, please don't understand, I'm not saying anything to you. But the chief secretary or the departmental secretaries who are parties to every litigation, are they not duty bound to look into it? What is wrong in the system? Why these compassionate cases of 2007, 8, 9 are coming up? And if there are litigations, you take up all those cases and then have it relooked without the order of the court. You see, after 5 years, what will we do? We'll say that the authorities will consider it. So take up those matters suo motu, empty the pending files of this court. If 10,000 cases go by, we can decide cases which require a determination. Or do that, or you increase the strength of the judges for 3 times. State government has the authority to do it. 24, make it 75. Every day lawyers will sit from 10:30 to 10:15 to 4:15. Answer to their clients, why cases were not taken up. Get a scolding from the client, get so many words said, bad words said about the judges. Everybody thinks we are just sitting idle and doing nothing. Please ask this chief secretary. In one given case, you give us those circulars. In one given case, we'll take exemplary action, and then everybody will, unless the fear of the court is instilled.
Yes,
When we were young juniors, there were courts where orders passed at 10:30 would be complied by 2 o'clock.
yes, sir.
You have seen those days,
Yes, sir.
correct? So we have seen those days. We will revive that.
so many cases are not released.
Ask them to do it. At one point of time, I'm bound to lose my cool. Compassionate appointment, we are dismissing it. It pains us. Yes, your matter. Yes, we had to call you again. You see, yesterday when we heard the matter, one issue which came to my notice when I started dictating the order is that you have pleaded in this writ petition that is a partnership firm. This partnership is not registered under the Partnership Act. Where is that statement? No document is there. No, but we don't know. Unless it is there, even arbitration. Because even in arbitration, there is I have a judgment where we have said that. Hmm. 49. No, this is. No. Registration and the registration are under firms and societies are different things. Page 50.
Presented for registration at 12
Aha, you're not following it. Under the Partnership Act, there is a non-obstante clause that if partnership is not registered under the firms and societies, then suits and proceedings will not lie. And our authorized judgment where suit and proceedings, I have authorized judgment where I said that the arbitration proceeding will also not. Do it, otherwise it will be a formal defect. And I don't know if there is any other judgment which is deemed to have overruled my opinion that a partnership firm, unless registered, even this proceeding would not be maintainable. If there is any other authority, then I'll be bound by it. No, whatever you time, we'll fix it. We'll fix it on next Wednesday. Thursday, there's some difficulty. No, not the next week. We have certain matters already fixed, which will. The last week, whenever you want, we'll take it up. 27th. 27th is a holiday here. 28th, yes, no issue. Advocate's name is so for the petitioner and the respondent is present. The matter was heard on 16/11/2023, but it was later on observed that the document relating to registration of the partnership firm in the registrar of firms and societies is not available, and therefore this matter has been relisted again at the instance of the court. The learned counsel for the petitioner placed for some time to obtain instructions and to file additional affidavit. No. You see, registration means that page para 1.
The duly registered partnership firm under the Indian Partnership Act.
No, it's okay. I'm not taking a negative view right now, but if you can show me the document, it's good enough. I'm not taking a negative view, but because if these are formal defects, I don't want to what you call. I'm not non-suiting any person on the ground of these small things. No, when you're filing it partner, if it will come to my bench, don't worry. Partner gives me a lot of botheration. Please try to understand. I have plenty of cup of tea. No, that's okay. You can, both of you can jointly pray before the registry to get it. Parted makes me difficult. I I lose some sleep with these parted matters. Yes, definitely you can try. I'm not opposing it, but keeping it parted because I'm allowing you to bring in a pleading. So you see, at the pleading stage, if I keep it parted, that would be I'm sitting over the matter. Yes.
It's only about the certificate you got knowledge, then keep it for the purpose of alternate while the evidence. Knowledge it's something which is not there knowledge, it's there.
It's okay. I'm not saying it, but if you can produce the document, if you can produce the document 2 o'clock, we'll take it up at 2 o'clock also. If you can do it, we'll take it up at 2.
So very. I'm giving you time.
Yes, item 2.
Last occasion, the earlier petitioners said that they have withdrawn to Kalar Namalas.
I see that, but there's another aspect.
Otherwise, Lordship, the particular order also, wherever the award was, Lordship, 82 lakh, that was stated by his honorable court in another institution.
No. You see, the issue here is different. The issue would be that this Wimco has been put up for what you call liquidation proceeding under the NCLT. So because of that, all proceedings would come to a halt. So that is the issue which is not addressed here.
It was not addressed here. Otherwise, also, Lordship, NCLT has also come before his honorable court by way of filing a restitution.
No, I'm aware of that because I've dealt with that litigation. Not only that, several litigations regarding unpaid dues of Wimco I've handled in different points of time in the bench. So
recently also, Wimco ITC has filed one petition, Lordship, 5/9/2020, Lordship. In this petition, whole proceeding was stayed.
there's no representation on behalf of the petitioner. However, Mr. K. Govil, an additional senior government advocate, is present. Here as additional advocate general, as government advocate or as CGC?
Yes, government.
As a additional senior government advocate for the state. Next, it is noticed that the petitioner remained unrepresented where the matter was previously listed on 17/10/2023. Next, the learned additional senior government advocate has submitted that the that as per his information, the company named Wimco Limited, in respect of which the present claim is made, is under liquidation under the NCLT. Next, be that as it may, as the petitioner remains unrepresented on the second consecutive day, the court is of the considered opinion that the petitioner is no longer interested to pursue this matter. Accordingly, this writ stands dismissed as non-prosecution. Item 4. Okay, Ms. G.S. Harika for respondent number 1.
Item 4.
Here, why this so long it has been litigating? Okay, because I have seen almost the pleadings are all completed.
Yes, it's all complete.
What is the issue? Since pleadings are completed, I did not go through it.
Actually, issue is, my lord, a particular tender was issued by the my lord ONGC for hiring water tank.
my lord, while quoting the rate, there is a requirement of quoting the rate as existing on the date of tender bid opening. My issue is, my lord, the rate which the audit company declares, whether it is accessible to all.
Means,
but my
what
lord,
does it mean? Accessible to all?
My lord, as a tenderer, I am not privy to the internal correspondence of
Okay.
IOCL.
Okay.
So unless it is available in the public domain, how do I know what is the rate prevailing on that particular? In fact, in court, a second was made by all of us, we could not do it. But on the contrary, if we charge the Google, my lord, we get it, but the price differs. So what we did, my lord, when I submitted my tender, I quoted my bid based on what is available in the Google. But it so turned out that actual price was less than what is public declared in the Google. That's the point. There is an interim order also we are protected that way. Only thing is, the lordship for admission takes up on Wednesday.
You are for IOCL.
No, I am ONGC.
You are for, this is ONGC matter. Okay. AGC employer.
I get for
So,
short point, my lord, like,
huh?
very short point.
And that is the point.
Because
Subject
I
matter
understand
says-
that.
So, if the rates are not available, how do you propose to?
I have to file the affidavit, I say my lord is available. I say that he is available, and he is a my lord, hearted my lord businessman, and in fact, my lord, in another tender, which was opened on next day, he has submitted this. I can place my lord. in the-
Okay.
I can place from the record. Now also I can place it, my lord. Because
See,
all
that is the,
all the tenders has submitted, my lord.
see, that is the only point.
No, my lord, in the earlier years, they used to give the rate.
It's okay. If that is the only issue,
Only,
we can take it up at the end of the day at 3:30 or something.
but they have some difficulty in the second half.
Okay.
Wednesday, my lord, Monday will not be there, that's why I'm saying,
Wednesday. Okay.
22nd.
Then I issue a short notice and then.
Yes, yes. And my lord, I think the notice part can be waived because everybody is empty.
No, notice will issue, but we'll dispense with the steps.
Yes. Regarding steps.
Heard Mr. Kane Chaudhary, senior counsel for the petitioner, assisted by Mr. Alan Dingia, counsel for the petitioner, and Mr. For the government CGC who will be there, you're there. Mr. K. Gogol, Learned CGC, appearing for the Union of India, and Mr. G. N. Savara, Learned senior counsel, assisted by Mr. N. Anik Singh, Learned counsel for the respondent number 2 and 3. Next, it is noticed that the pleadings of both sides have been exchanged. So therefore, letter formal notice returnable on make it Wednesday, Thursday. Okay. Wednesday.
Thursday.
Okay. Returnable on.
It will be Wednesday. Thursday, actually, my lord, other matters, lordship is already fixed.
Okay. 22, 11/2023.
Since it is a motion there with the understanding, it can be taken up in the second half.
Second
before
half.
we can make a prayer.
Most admission.
22/3/2023. 22/11/23. Without requiring any fresh steps to be taken.
Yes.
This the repetition along with the connected interlocutory application shall be taken up on this said returnable date expired list on 22/11/2023.
As admission.
As admission. With the understanding, my lord, lordship did not indicate, we'll do it in the second half, lordship may take up the other. Interim will continue till.
Interim order past 30 days stands extended till the next date of listing.
Diplomat.
Item 5,
Lordship,
Yes.
petitioners are scheduled tribes residing in the Berlangpur district of the Berlangpur Reserve Forest, Lordship, in Karbi Angle district. Lordship, now there is an act, Lordship, scheduled tribes and other traditional forest dwellers recognition of forest rights Act of 2006, under which there is a detailed procedure laid down for recognition of their rights. So they have made several applications.
No, was your original status as a refugee? I think you are claiming you are a Chakma.
Yes, yes.
Are you of Indian origin or you are refugee? Your status was refugee, Indian origin.
Initially, they gave me an RTA reply whereby they communicated that the district level committee was not constituted. Now, latest RTA reply says that it has been constituted, and I have also got a notification to the effect Lordship. So my only prayer is that Lordship, they may be subjected to the procedure laid down under this Act, Lordship, 2006 Act. Latest RTA reply is that
Will issue a notice? You have anything to say?
we were directed to seek instructions.
Yes, Lordship. Lordship, they have, the petitioner has provided us extra copy on 15/11, Lordship. Therefore, we could not take the instruction, Lordship. On 15/11, they have served the copy. Extra.
Okay. Your name?
DJ Sharma.
Uh, Dr. G.J. Sharma, counsel for the petitioners. Mr.
RS Rohan, okay, is
R.H. Rohan.
RS
Rohan, standing counsel for the KAC has submitted that he has received extra copies of the writ petition only on 15/11/2023, and therefore he could not obtain instructions. Mr. B. Chaudhary, counsel for the standing counsel for respondent number 1 and 5 present. Next, review of the issue raised in the present writ petition. That a notice returnable in 4 weeks be issued. Requisite extra copies of the writ petition be served on the Runnet State and Departmental Council in the course of the day. Already served to all. Let's say the Runnet Council for the petitioner submits that extra copies of the petition has already been served on the appearing council for the respondents. List after 4 weeks, by which time the respondents shall obtain instructions and file affidavit in opposition in the matter. Respondent 2, Ms. G. Hazarika, counsel for respondent 2.
Item 6.
I'll issue a short notice here because this is hospital services. I'm not giving an interim, but notice I'm issuing for 2 weeks.
Selected bidder has already started functioning.
No, that may be, but it will be subject to outcome.
Yes, my lord, it will be subject to outcome.
But since it is hospital services, I'm not interfering.
And the minute shows that, my lord, I have, with the minute, it shows that, my lord, the private respondent has submitted all the requisite documents, my lord.
Some of the document is there, does not, my lord, comply the.
No, but if they have it in record, we won't, if it's available, we'll give you copies and we'll take it up on the motion on the next date. Take instructions.
I have annexed the documents, my lord, of the private respondent, my lord. I have annexed the documents, my lord.
Which document? Show us a document which you say is not there.
Yes, I have annexed. From my lord, page number,
Just show me one document.
page number 61 onwards. my lord, of the-
Page number
61 onwards.
61.
From the experience, my lord, of the petition, it is mentioned in the Indian criteria, my lord, that 3 years experience is necessary, my lord. But my lord, here regarding experience, my lord, one of the was clinic, my lord, not a hospital of Ankuram Hospital name, my lord. The annexure itself, my lord, that is, my lord,
Just a moment.
incomplete information, my lord, given in the experience certificate, my lord. Area of the hospital is not, my number of beds, my lord, very important, my lord. Number of employees, nothing is there of the experience submitted from the hospital, my lord. It is a clinic, my lord, and my lord,
Annexure 2, page number 62, I have my lord eligibility criteria regarding the company's my lord qualification. The documents are not my lord mentioned. From 8, my lord, your lordship will find page number 62 from 7, 8, 9, 10. No specific answer is there, my lord, regarding the ground of the response number 5, my lord. No specific answer is given, my lord, regarding the whether it was blacklisted or convicted, my lord, does not arise, my lord. Blacklisting does not arise. So the background is, my lord, did not, my lord, reflect from the documents annexed, my lord. And moreover, my lord, in the eligibility criteria, page number 33, your lordship will find.
Just one.
Yes.
Okay, after page 61, which other page?
My lord, may I do your lordship, page number 33 is important of the bid document, my lord. Page number 33, the eligibility criteria, my lord, my lord. Yes, I will say.
Page?
Page 33.
33.
Yes. This is the eligibility criteria, which is my challenge, my lord. Page number 33.
Yes, 33.
Yes, this is the eligibility criteria, my lord. Number 1 and 2 nice feet, my lord. From C, my lord, onwards, my lord. 3 years experience in the cleaning and sanitation. Bidder should have executed cleaning sanitation service, government and private hospital. Details of the experience in at least 5 years should be submitted as per Annexure 1. Proof of successful execution along with certified copy of the award work agreement of the above mentioned work should be submitted. Also, the bidder must have, this is important, my lord, experience in Goft Hospital, which is absent, my lord. And number D, bidder should have not incurred loss, that payment slip, my lord. Number E, registration certificate from statutory bodies, bidder should adhere. My lord, this E is only to 2023, my lord, whereas experiences of 5 years may not required. Number F, bidder should have an average annual turnover amount equal to or greater than 10 crore. Their documents shows, my lord, 2 to 3 crore, my lord. It is 10 crore eligibility criteria. G is bidder will also have to make written submission detailed work plans.
Okay.
My lord,
Okay.
my last one, my lord, for a moment, my lord. In the absence of any of the above mentioned document, it will be rejected, my lord. So when I have annexed the document, the absence of that is eligibility criteria is there, my lord.
Okay.
For a moment, page number 75, my lord.
It's okay, we are issuing a notice. Right now, I'm not giving an interim review, but I'll make that mention.
Okay.
Had Mr. M.J. Kadir, counsel for the petitioner, and Mr. D.P. Bora, and standing counsel for the health department,
For 1 to 3.
representing respondent numbers 1, 2, and 3.
1 to 3.
One, two, three, 4 also, I think.
Yes, my lord. 1 to 3.
1 to 4. The by referring to the eligibility criteria for qualification contained in page 14 of the bid document, the learned counsel for the petitioner has submitted that that he has annexed the documents of the respondent number 5. It is petition project that the respondent number 5 does not meet the eligibility criteria to be awarded the contract for providing cleaning services in Assam Medical College and Hospital, Dibrugarh. And therefore, the selection and engagement of the respondent number 5 by the respondent authorities is under challenge in the present writ petition filed under Article 226 of the Constitution of India. Issue notice, including notice on the prayer for interim relief returnable in 3 weeks. Requisite extra copies of the writ petition will be served on the learned departmental counsel in course of the day. Most of the petitioner shall take steps in course of the day for service of notice on the respondent number 5 by registered post with agent.
5 and 6.
5 and 6, my lord.
5 and 6. Okay, 5 and 6.
It's the second lowest bidder.
Pardon me?
6 is the second lowest bidder.
Okay.
5 is the
Oh,
lowest
okay.
bidder.
First of as the petitioner has given, has provided specific statement with regard to eligibility, lack of eligibility of respondent number 5, comma, the court expects the respondent authorities to respond to this writ petition within the next returnable date. Next para, list on so and so for awaiting service report, as well as for considering the prayer for interim relief. Next para, the selection and appointment of respondent number 5 as the selected contractor for outsourcing of cleaning service in the AMCH Dibrugarh, be subject to further orders that may be passed by this court on the next date. The instructions produced by the learned study counsel for the health department is not instructions. Document produced by learned study counsel for health department is returned.
Okay.
Next date after that. We said that. Dusty. Okay, Dusty on 5. Just
Why not six
I
is
feel
also
service.
necessary because he is L2, 6 is L2. And the lowest bidder is restaurant number 5.
No, it's okay, but first is that
No, for
okay.
his benefit, I am saying.
No, but Dusty is
Because if
everybody.
restaurant number 5 goes, then the restaurant number 6 will
No,
come.
for him it will be difficult to serve on the restaurant number 6. He is ultimately a businessman.
Even if restaurant number 5 goes, then restaurant number 6 will come.
6 will
because he is
come.
the second lowest bidder.
6 will come.
Yes, madam.
But he's saying 5. Why should I
Yes.
add 6 to him?
Yes, madam. Obliged.
He may have some difficulties.
Yes, madam.
No, I'm not giving a fixed date. Make a mention if it's not listed.
Item 7.
Item 7. Earnest money, not return.
Interest money and other deposits, my lord.
Okay.
You also is there, my lord.
My lord, issue of this, and between the
Mr. J. R.
partners,
Mehboob,
they have-
counsel for the petitioner, and Mr. K. Gogoi, additional senior government advocate for the respondents. Non-release of security and security money, earnest money, and other dues. On the present writ petition has been filed under Article 226. Notice step extra copies. Pendency shall not be above.
So see, I am for 1 to 5.
1 to 5.
6 to 8 lords is notice of goal.
6 to 8 notice has to be issued. Notice. Notice steps within 2 days. Okay.
6, 7, 8, my lord, apart from my lord. Rest of us will be permitted to serve Dusty.
6, 7, and 8. Okay.
6,
In
7,
addition,
8.
notice to be served on respondent number 6, 7, and 8 by way of Dusty by routing the process to the institute. Make that under order. Okay.
Attendance of this may not be barred.
Already ordered.
Process fixing the matter, my lord.
After 4 weeks.
Can it be 3 weeks, my lord, my big amount is there.
No, it's you see it's service if it is there. We can't take what do you call the service can't be presumed before that.
No, my lord, I will serve, my lord, during in Monday, my lord.
Then lordship, between the partners, there is a lordship some dispute is going on between the partners also lordship. So we cannot even.
No, whatever be 4 weeks.
Item 8.
We'll only issue a notice, Mrs. Chaudhary. But there is a question, but I'm just posing it, but I'm not taking any adverse view right now. In this matter, what I could understood from the documents is that the participation is only by cooperative societies.
But Madam, the individual 5, there are 7.
No, there may be how many bidders, I don't know, but from the tender document appears that the participation is open only for cooperative societies.
But-
And you are not cooperative society.
But there is a clause in the tender notice that individual belonging to Maiman community or fishery community of
Show me that,
page 18, Madam,
page.
18. Translated version, Madam, and the vernacular is at page 20, Madam.
No, the tender can be submitted by cooperative societies consisting of members from 100% scheduled caste community of actual fishermen and mammal community. It doesn't say,
Or actual fishermen from scheduled caste.
no, or actual fishermen, maybe anybody. I may also belong to a fisherman community you don't know. I may be a vegetarian man, but but my ancestral profession could have been fishing.
Vernacular also it is given very specific.
No, I understand, but you see, we are interpreting a document. First criteria, it says it should be a cooperative society consisting of so and so. So consisting of X, Y, Z, ABC. I'm just posing a question. I may not be I'm a strict vegetarian, but I may belong to that community. By choice, I'm a vegetarian. It may so happen. But if I belong to that community, why can't I fish? But the question is that here the fishery is open only for cooperative society, that's why.
Or individual belonging to minorities.
No, no,
In the
or will be, you see, or would mean what?
That is why all the.
No, you see, in a plain reading, or would mean it's a connective. Either 100% fisherman or so community or other fishermen. You see, tomorrow, let us say this fishing community of sea fishing, say from Odisha or from Kerala or somewhere, the people who are engaged in fishing in sea, high seas, they come and say that I am a fisherman community and therefore I want to participate. So he will also be allowed to be participated because he doesn't belong to that other two communities, but he is a fisherman of third category. All fishermen would not be individual because the first line says cooperative society. I'm issuing a notice, but I'm not taking an address you right now. Her Mrs. S.B. Chaudhary, counsel for the petitioner, and Mr. M. Chittiar and government advocate appearing for all the respondents.
No, madam, number 4 and 5, madam, 4 say they are telling us.
You are only for 4 and 5.
4 and 5.
And who is for fishery?
He's Sharma, yes, ma'am.
P. Sharma.
Yes, sir.
Okay, and Mr. P. Sharma, then standing counsel for Fisheries Department, appearing for respondent number 1, 2, and 3. Keeping the issue as to whether the petitioner is eligible for being settled with the fishery in question, issue notice returnable in 4 weeks. Requisite extra copies of the writ petition served on the learned state and department council in course of the day. Notice including notice on the prayer for interim relief. Next, the learned standing counsel for the Fisheries Department shall be ready with instructions for the purpose of hearing the petitioner on the prayer for interim relief on the next date. List after 4 weeks. Oh, acha, 5 notice steps within the course of the day. Okay. Mr. Sharma, you'll on the next date you'll have to address the matter in respect of the prayer for interim relief that we are adjourning on the next date. There's one more thing. You have a copy of the writ petition?
Yes, it is not higher.
You have. Oh, okay. Now tell us this cooperative, this fishery bidding is open for individual fishery or only for cooperative society?
Cooperative society, rule also provided them.
No, I don't know.
I'm also very new to this. I will get instructions.
You take instruction on that matter. 4 weeks. What do you call the fishery has been allotted to someone? Not yet finalized. Okay.
Item 9.
Non-payment of contractual bills. Your name?
I'm on behalf of Mrs. K.K. Chaudhary.
Your name?
D. Kalita.
G. Kalita. D. Ms. D. Kalita for the petitioner and Mr. R.M. Das, standing counsel for the Water Resources Department. Non-payment of contractual bills. Notice steps. Extra copies. Pendency shall not be barred. Give them extra copies in course of the day.
Item 10.
Petitioner is a private limited company. Here the petitioner is a private limited company and engaged in the business of security services.
Oh,
The respondent authority processes tender
of security service.
security service. The respondent floated the tender and accordingly the petitioner participated in the tender. And in technical bit, the petitioner is partially and it comes to page 92. Not 92 noted.
Okay, they should notice here.
Here, in a individual, they disqualify us on the ground that we are, they disqualify another company, that is partnership firm, and they consider that we and they same.
It's okay, we should notice.
Some protection will be given.
No
They
protection.
are not open the financial.
No protection. We'll make it subject to outcome of the writ petition.
To take, lordship allow us to take the justice service.
Okay.
Lordship, I'm for the excise department.
For the excise. Excise is a party here, no?
No,
Either you're in a wrong matter or a wrong court. Uh, you can obtain instructions in fact, the disqualification, he says that is on the ground that the party disqualified has the same name.
lordship, in fact, we are the existing contender in the same work, and they extend our work.
Number two, three and four also. Number two, you have quoted the tender also, multiple goal also. In respect to number two also.
No, his case is that there are two firms of the same name.
Not same name, lordship. Names are also different.
Names are different.
Names
Where is the order of dejection?
Page number 92, lordship.
92.
So lordship, already calculated corporation limited lordship, so they have to come. We only represent lordship, the ministry of.
Okay, 92.
Page number 92. The first lordship, 21/10/2023, they qualified us in technical bit, techno commercial acceptable. Then surprisingly on 2/11/2023,
It doesn't inspire confidence.
Lordship,
Doesn't inspire confidence. Your stand doesn't inspire confidence. There are two things. Number one, the website of both of your firms are absolutely similar, except for the name. The two websites are absolutely similar. Number one. Second, this Vanguard's had a partnership firm. You retired from that firm as a partner and started a company. So your antecedents of being a partner of a band company will carry with you.
In a oil, our vendor number is different, their vendor.
No, that may be say, but we are
Incorporated as a company.
no. It doesn't appeal to us. You can't by retirement from a firm of a band organization. You can't shed off your what you call cloak, which you had.
Then the oil ban that partnership come to this.
No, it's okay.
2022.
That's
And
okay.
Our company is started in 2019.
We'll issue that. Yeah. Your name?
JP Moore.
Mr. JP Moore, counsel for the petitioner. And Mr. K. Gogoi Leonard, CEC appearing for respondent number 1.
I can also see the government of India under the I can.
No, but if you appear for 2, you'll have to appear for 1, 2 to 5. all our officers. Will appear for all, for all the respondents. The petitioner projects that the though the though one of the directors of the petitioner company was earlier a partner of
The director.
Vanguard's VNGUARDS Security Services symbolic and symbol and systems. But he had retired from the said partnership on 7/11/2009 and started his own and started his own company, which is presently engaged as a security contractor in respondent number 2 corporation. But in connection with the NIT dated 23/8/2023, the respondent, the authorities of respondent numbers 2 to 5 have treated the petitioner company as a banned entity. And had not never a banned entity. And therefore it is appeared that the petitioner would be disqualified on said ground. And accordingly, the disqualification of the petitioner in the tender process is challenged in the present writ petition filed under Article 226 of the Constitution of India. Issue notice returnable. In security issue will issue 3 weeks notice. Notice including notice on the prayer for interim relief returnable in 3 weeks. Requisite extra copies of the writ petition be served on the learned CGC in course of the day. Next para. The finalization of tender shall be subject to further outcome of further orders that may be passed in the writ petition. You take your document. You take your document.
Item 11.
Yes, trade license not issued. Why? We'll call the officers here. We'll call the officers here. Let them work. We'll give them a table for 2 hours or 3 hours, whatever they want. You take telephonic instructions and tell us at 2 o'clock. Because if people start coming here for non-renewal of trade license, non-renewal of X license, Y license, I'll be happily taking up all those renewal. I'll start a window here at 2 o'clock. If it is not at 2 o'clock, then the officers will be here and doing work here. at 2 o'clock. Ask them to be here. To give you instructions, or at 2 o'clock, we are starting a window here for renewal of trade license. These people will personally appear at 10:30, at 10:15 on Tuesday and start working here. All trade license renewal will be done here in this corridor.
Okay.
At 2 o'clock. Item 12. Unpaid contractor bill. I'll issue notice. Unpaid contractor bills. Mr. B. Barwa, counsel for the petitioner, and Mr. RM Das, standing counsel for the NCL's Autonomous Council, and Mr. R. Dhar, standing counsel for the PWD. Unpaid contractor bills. Notice extra copies. Pendency shall not be about 4 weeks.
Supply item 49.
Yes.
Well, better part is to.
No, I'm aware of it.
Yes, madam.
Why the orders are, why the your own act is not complied with? He had a PDS license suspended. He filed a appeal. It has not been disposed of within 90 days as provided under the Assam articles order. So what do we do? At 2 o'clock. At 2 o'clock, these things should not go on. If the officers don't work, we'll give them all table here in the High Court premises. We have a next door empty table, empty what you call property. We'll ask them to come with table and chair and start working here.
No,
Ask the deputy commissioner if is wanting to dispose of within the 90 days time is already expired. If he can dispose it of within 10 days, okay. Otherwise, I'll call these deputy commissioners and all. I'll give them space here to put up table and do work at 2 o'clock.
I'll take it.
Yes, do it. Otherwise, if you don't give citizens any service, I'll be the one who will be bothered. If I am bothered, why not call this all people and make them work here under my supervision?
Item 50.
An instruction launcher. CF has received the application. He has filed the report to DFO regarding the quantity in the permit. After report comes, that matter goes to the government, because the government is the competent to take the call whether the surrender application can be accepted or not.
Okay. Good enough. We'll issue notice and keep it pending.
Very well.
In the meantime, we say that the pendency shall not be a bar for the authorities to. Huh?
Has already indicated that last order.
No, I have not issued notice.
Yes.
While doing it, I have to issue notice now. Mr. Biridas, Learned Senior Counsel, assisted by Mr. D. Kalita, counsel for the petitioner, was pursuant to order dated 14/11/2023, the Learned Standing Counsel for the Forest Department has submitted that as per instructions received by him, due process will be followed to entertain the application of the petitioner for surrender of the permit and for non-enforcement of and pay for non-enforcement of the fifth kiss money in respect of the permit area. Correct? Next, in view of above, letter notice returnable in 4 weeks be issued. requisite extra copies of the representation is served on the learned standing counsel for the respondents in course of the day. Next para, the interim order passed on 14/11/2023, not to take coercive action against the petitioner. Stands extended to the next for recovery of fifth kist money. Stands extended to the next date of listing. Next para, the pendency of the writ petition shall not be a bar for the respondent authorities to examine the prayer of the petitioner for surrender of the sand permit in question and take an appropriate decision thereon. List-
Next day, may I say, until further order also.
Next date of listing, because you see there, because we retain that power to revoke it.
Nothing of that, you know, she can book it at any time. Recently, I faced some petition where the order was not extended. because-
I have said next date of listing. I am not saying 4 weeks. I am saying next date of listing. Listing may be even after it is after two months, you are protected. No, I know that. I know that. Because we have found those issues coming up.
2 cases, we also.
No, not 1 and 2. There are plenty of cases. You are absolutely right. That's
But there
why.
is a decision I was told by Honorable Justice Mr. Borwa, that unless it is vacated by an order giving reason, so the same order remains, although it is not extended. There is a judgment.
Okay, I'm not aware of that.
That judgment, we have found some judgment, but 3 years of the past.
Okay. No, because you see, those experience I have in one of the matters long back, about I think it was before COVID. There was a very strong fight at the bar by both sides for the interim order having vacated or not vacated. So when I was dealing with it, what I did was the order was technically found to be vacated, so it was vacated, and it was the interim order was renewed then. Fresh order was passed. So at times, you are absolutely right when you say that.
No, but the judgment, if I show you, I'll show you before lordship next day. Judgment protects the petition, even if it is not extended, my lord, unless it is vacated, my lord, by a speaking order, it remains. I'll show the judgment.
That's why after that, I am casting my orders as the interim order till the next date of listing. So therefore, this is how I'm protecting after that.
Next day of the listing, due to paucity of time, it has not reached.
No, but no. In my court, that if somebody makes that statement, it would be a wrong statement, because even after I rise, in my courtroom, I have authorized my court master and my secretary. If anybody says that there is an interim order to be extended, they are doing it. In my court, at least nobody can say. If he says that, that means he was negligent in observing the last statement in the courtroom. Every day, day in and day out, in my courtroom, I can't say for others, but in my courtroom, even if I rise for any reason, they take the case numbers, name of the lawyers, and will report it to me, and then I extend the interim orders. That is what I have devised in my courtroom.
All right.
Huh? Yeah, yes, Mr. Das. My court master again clarified very softly and politely, sir, we are strictly following that. No, it's reported. You see, what happens, Mr. Das, we know our limitations.
I know.
At times we have some administrative works, some meetings,
Yes, a lot of.
and then at times there is some urgency to go home. So that therefore you see, these are just devices so that the lawyers do not suffer. That is first. There is one thing. The second is at times even urgent orders. I know it is urgent, but by the time it is transcribed, retyped, the system is shut down. In our system, the only way to protect it is to shut down it after a particular point of time, so that others cannot hack. So within the time when this IT department is present, till that time the interactive portal is open, means two-way communication can go on. But at one point of time, it is shut down so that there is only one-way communication, so to stop it from hacking. So
But
therefore,
what I was trying to point out for this honorable court is that, because of the judgment, which says, unless it is vacated by speaking order.
no, please make me aware of that.
So therefore, the intention of the order is that it will remain until vacated. So therefore, it is, might as well, the interim order will continue until order. Because it will protect everybody.
No,
I'm just
no,
pointing,
Mr. Das, perspective will change. I'll tell you why.
because they will file a
No,
petition
I'll tell
for
you.
vacating.
I'll tell you why. Because then I'll be compelling people to come with an application for modification or vacating.
That has to be filed.
No,
They want
but
that
if I'm giving an interim order with a limitation, that means even without that application, I can still hear and vacate it. So I'm in fact saving trouble for the litigants. If you say so, we'll change the system.
No,
But the fact is that supposing you are appealing for a no, not that. You see, I can say for myself, and I'm telling you the reasons so that if I'm at fault, you can point me out that whether I'm in fault. Now you see, the intention of giving a interim order with a limitation is only to enable that supposing you appear today, tomorrow as a respondent, then you don't have to file an application for vacating of the interim order. You can hear it on merit and that it can be extended, it may not be extended. So that is my reason of giving a interim order for a limited period. But if I change the system, I think then everybody will have to file an application for vacating, otherwise it remains. Let us say that your right has been curtailed for some reason. And you'll have to not only come, appear before the court, file an application for modification, then again. So this is what is my intention. 51. Yes. Yeah.
Well, as it was directed over discussion. Provide the medical information of state and the purpose of the page.
Oh, it is there. They are highlighting that the finance department of the government of Assam, they have come out with a policy decision. So we'll issue a notice, you give a response. You may go through it, we'll take it up after some time. Please go through it. Because they say that it's a policy change. And because of that policy change of the finance, therefore all the other tenders have been revised based on that policy decision.
In order to kind of get the relief, I have to challenge the policy decision.
That's why please go through it. Since I only had an overview, I won't make a comment.
Item 52.
52, 53 same.
Yes, fine.
52, 53 same. Officer.
আৰু ইন্টাৰিম উকিল বিলাকে বেছি দীঘলীয়াকে বিচাৰে মই উইদিন
Maybe.
54.
Maybe.
Mining lease granted and then cancelled. You have instructions?
Let's look into my lord.
And granting to another
Annexer
without
D
any
page
competitive
18.
bidding.
Let me.
Annexer D page 18. Annexer D page 18.
18. Okay.
This is the allotment order, my lord.
Hmm.
Issued on 16/3/2023.
Hmm.
The second paragraph. The bidder shall have to deposit the offered highest settled value in full and in one installment before carrying out the extraction. Petitioner has not made any statement that he has deposited the amount. And my instruction, telephonic instruction, that petitioner has not deposited the amount.
Okay, then I'll issue a notice.
But not, what I'll, initially we have to pay 10% deposit, thereafter 15% deposit as per the rules. That I have paid. After the mining plan has been approved, that is approved on 5th August, we have to deposit our royalty and the other deposits. So only after that, when I went to deposit these amounts, they had handed over me this cancellation. And they have unauthorizedly given to another fellow. Lordship, page number 21, Lordship.
We will issue a notice because once they have been allotted, we will issue a notice making it subject to outcome of other orders.
No, Lordship, I restrain the mining
No,
operation
no.
of the private respondent.
I am not doing it, but I'll make it return on the returnable date. It will be made subject to further orders, which I'll pass.
Lordship, there are statutory rules at least, Lordship, before cancellation, act permits a notice. I will show the statutory provision.
It's okay, but you see, once they have done it and they have a reason for doing it, we'll see that.
Lordship, the cancellation order does not
Allotment
give any
order
reason.
is specific. Allotment order is specific. They have to deposit in the full amount.
It's okay, we're issuing a
He has
notice
not yet
right now.
deposit the amount. And
We're
he has
issuing a
not made
notice.
any
No,
statement.
no, Mr. Bora has a point. If the mining plan is not approved, by then why
Without
will he?
approving the mining plan, allotment also cannot be made, my lord. Without approving the mining plan, my lord, by the department, my lord, allotment also cannot be made, my lord. So the allotment is required to be cancelled also on that point also.
No. You see, that is your system because no, it's not in one litigation we have found it.
Right.
The system is that in in this mining operations, you give a tender, and then the mining plan is chopped out. You give a time limit, and within that time limit, if they get procure it or if they want an extension, you grant that extension, and then mining plan is approved, and then other formalities come. So Mr. Bora has a point. It's not that he does not have a point.
One more thing, Lordship, as per the Mines and Minerals Act, Lordship, premature termination will be preceded by opportunity of at least a notice and a hearing. Lordship, I will just read out
Where is that?
section 4A of the Mines and Minerals Development Regulation Act 1957. The rules of 2030 is made under this.
Just one. Mines and minerals rules. Take it up to. You are looking at the Central Act or the Assam rules?
Yes, Lordship, Lordship, I can give my.
Aneka kitab to itu. Aneka kitab to.
Lordship, sorry, it is marked. The rules. And Lordship, if I violated any of the conditions, there is a procedure for termination. That is on the rules, Rule 54 and 55
Rule 54 and 55.
of the 2013 rules. At the last part, it is here. If there is a breach of any condition. 2013 rules.
50?
55,
Acha.
mining can only be settled by competitive bidding. That is also there in the act. Rule 37 logic because of what to pay, the bid security and everything in 37. One can understand if suppose second highest bidder is given the settlement, then also it is reasonable. I feel second highest bidder gets it. This person comes from nowhere. There is a deemed concept cancellation provision also under 37. But that is not reflected in the termination. That for this reason I think. Nowhere in the statutory rules I could find that the payment that could be made in full only 25% as per 37, firstly 10% and then 15% has to be paid.
But that was a term you accepted it.
What is the kindly look at?
Just
now.
now. Just now. Yes, Mr. Sutia.
Lordship, look into my lord, rule 24(4)
24.
is 261
Just
of the book. In case of permit granted under this rule, the permit holder shall execute an agreement in Form MPS 1 with the competent authority within a period of 90 days from the date of grant and shall be duly registered. Petitioner has not made any statement, he has made the agreement, execute the agreement. He has not made the statement. And the petitioner has not annexed my lord tender document also, my lord. What is the terms and conditions of tender? That is not before your lordship at this moment, my lord. And lordship may look into the annexer 19 or annex page 19, annexer E, page 20, the relevant part. Page 20, what is required to be made by the petitioner, my lord? Page 20, clause 4B. For duly approved mining plan, which is mandatory under the provisions of Rule 48 of the Assam Minor and Mineral Concession Rule 2013, and submit the same within a period of 45 days from the date of issue of letter of LOI. In addition to the above, you shall be liable to pay the government dues as and when necessary. So the statutory duty the petitioner fails to, my lord, fulfill, my lord. So the council have the power to cancel it, my lord. And this is my preliminary submission. I will take the, my lord, definite instruction, my lord. At this stage, lordship may grant some time to take the instruction, my lord. These two vital documents are not before your lordship at this moment, my lord. Tender document, NIT, and my lord, whether he has made the agreement within 90 days or not, my lord. And third is the, my lord, that he has not deposited the amount, my lord, as per the order, my lord, dated 16/3/2023. Yeah.
But Mr. Sutia,
My lord,
I think your initial order
my lord.
will carry no meaning in view of annexure E at page 19.
If the order is not bad in law, my lord, that is required to be cancelled. That is in honest in our law, my lord. If the initial order is bad in law for not fulfilling the condition of the
No. You see, initially whatever you have said,
my lord,
but you have issued an LOI.
my lord,
Terms of the LOI will prevail.
my lord.
LOI does not say for full amount to
LOI,
be.
my lord, LOI is of 5/4/2022. If your lordship look into the date, my lord, page 20, memo number dated 5/4/2022.
Yes.
And that order is of 2023. 16/3/2023. Page 18.
It's their document, lordship, it is wrongly.
I have to take the instruction, my
It's
lord.
wrongly because it refers to documents of 2023. Therefore, the date is wrong, I think. It should be
Correct.
5/4.
You are right. He is right. Because in reference, you are giving letter of 23. In 22, you could not have foreseen
My
that letter.
My lord.
And
Hmm.
moreover,
Yes.
as my senior counsel has referred that we should execute the agreement on after 45 days after the mining is approved. Therefore, kindly see page 23, para 4. Mining plan, as per my representation, was approved on 5th August 23. Now on 18 August, my thing has been cancelled. Para 4, lordship, last line. That the Director of Geology and Mining, Vikran Bhavat, has been approved in respect of Dhanti Nagaon Basti, dated 5/8/2023. My cancellation order is of 18/8. Approval is of 5/8. Therefore, 45 days notice has not elapsed. Then giving to somebody who has not even participated in the tender. Absolutely illegal.
What's it? We have three, my lord.
Just
So
a-
keep this on the, my lord, next Wednesday, my lord. And take the
Just one.
instruction whether if any remedial measures are required to be taken also, whether that can be
Just,
taken or not.
just a moment. Mr. Bora, from which provision you are saying that it should be 45 days from the date of mining plan?
Yes, just my learning senior council has referred, he has read it out to your lordship, I have just heard it. 45 days.
Page 20, my lord.
45 days,
Rule 48.
rule 48.
48.
Rule 40 is a mining plan.
Mining plan, my lord. Any mining operation under a mineral concession granted under these rules shall be undertaken by the mineral concession order in accordance with the duly approved mining plan, my lord.
No, no, I'm asking that this agreement should be,
24, my lord.
agreement should be made within how many days?
24, my lord.
That is 90 days.
90 days.
So, no, Mr. Bora has said that it should be 45 days from the submission of mining plan.
Lordship, my learning senior has just read it out, read 45 days.
Page 20, my lord. Page 20.
20 years. And there,
Page 20, my lord. B, for duly approved mining plan, which is mandatory under the provisions of the Rule 48 of the Assam Minor Mineral Concession Rule 2013 and submit.
mining plan is 45 days.
Within the
45 days.
No, no, not agreement. Agreement is 90 days.
90
The rules will prevail. Okay.
May I pray to take up this matter on Wednesday, my lord, so that I can get the instruction and my lord, if any remedial measures are required to be taken, whether that can. It will be, my lord.
But this 7, the allotment to 7
My lord,
shall be subject to orders of the court.
my lord, my
Uh,
lord.
Heard,
If my lord.
Mr.
If your lordship only fix it, my lord, if the remedial measures, my lord, if all these things are required to be corrected also, my lord.
No, no, but you see, whatever be done,
My lord,
but his selection
my lord. My lord.
is out of the blue.
my lord.
Is out of the blue.
So, my lord, that is.
You can
so
go
on
for a
that point, my
retender.
lord, so on that particular, on that point, my lord,
No, it's okay, but I'm making a mention that it will be
Well,
subject to orders of the court because this can't be permitted.
my lord.
Lordship is staying
And
and
lordship
lordship
may-
number 7.
No, 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 I'm not saying it right now. Heard Mr.
Lordship is fixing it on Wednesday.
Wednesday. Heard Mr. BP Bora, counsel for the petitioner, as well as Mr. J. Sutiyal, and standing counsel for the AAAC, representing respondent numbers 3 to
Phone number
6.
5, 3, 4, 5, 6.
3 to 6, and Mr. R. Goyed, and standing counsel for the forest department, representing respondent numbers 1, 2, and 3.
1 and 12.
1 and 2. Who's for 3 then?
My lord.
Oh, 3 is by you. 3. Okay, okay. Right.
My lord.
Uh,
There is a provision of appeal. If the petitioner made the special chief conservator of forest Karbi Anglong as council of heritage party, my lord. So if it is, then the appeal can be sent to the, my lord, that particular provisions in the rule, my lord.
Which provision?
68, my lord, page 289 of the book.
289.
289. Unless otherwise provided, an appeal against the order passed by the subordinate officer shall lie with the director, principal chief conservator of forest and head of forest office Assam, as the case may be. An appeal against the order of principal chief conservator lies with the government by law. So there is a special principal chief conservator of forest and council head of Karbi Anglong Autonomous, Karbi Anglong, my lord. So if he is made a party, my lord, so
No, not you got to make a party. We'll make a mention.
Fine,
You
fine.
will give him permission to move the authority. We will
my-
an appeal.
my-
Uh, by filing this writ petition under Article 226 of the Constitution of India, it is projected by the petitioner that pursuant to NIT dated 30/12/2023, 2022, the petitioner was settled with LOI dated 5/4/2022 within bracket SIC ought to be 5/4/2023 bracket closed, granting mining permit to allow mineral concession in respect of mining area Dhansari, DHAN SARI, River Sand Mahal at Nagaon Basti, NAGAON Basti. However, without any prior notice to show cause, by the impugned communication dated 19/8/2023, the settlement of the said Sand Mahal was cancelled. And accordingly, this writ petition under Article 226 of the Constitution of India. Next, the Honorable Counsel for the petitioner has submitted that under the Assam Minor Mineral Concession Rules, 2012, 13, cancellation must proceed with a show cause notice. And moreover, it is submitted that after cancellation of the Sand Mahal, settlement of Sand Mahal of the to the petitioner, the respondent number 7 has been allowed mining concession without any tender process and though he was not the second highest or third highest bidder. Next, opposing the prayer for interim relief, the Learned Standing Council for the KAAC has submitted that the petitioner is not disclosed in this petition as to whether any agreement has been entered into with the respondent authorities or that in accordance with Rule 24 within bracket 4 of the set 2013 rules. And also there is no statement as to whether as per the requirement of letter dated 16/3 2023 by the Secretary, Department of Environment and Forest, KAAC, the full the full settled value has been paid within one installment. Next financial notice returnable in Wednesday. Returnable on 22,
Friday,
huh?
Friday one.
On 24/11/2023. Requisite extra copies of the petition be served on the United State and Department Council in course of the day. Next para. Notice including notice and the prayer for interim relief. Having regard to the fact that the projection in this petition is that the respondent number 7 was not a bidder in the tendering process and has been allotted the mining concession. Without any tender process. The as an interim measure, the court is inclined to provide that in the event the respondent number 7 has been allotted the mining area without following the tender process. The said settlement shall be kept against till the next returnable date. However, this order shall not come in the way of the respondent number 7 to operate the mining area if he has been settled with the said mining area if he was the second highest bidder in the NIT process initiated on 30/12/2022. It should be 30/12/2022.
Ordered it 12/12/2022. Annexure E.
Because at page 15, the Sen Mahal is created on 12/12/2022 for the first time. It is a creation order. Page 15.
No. In your, I'm asking you this question because in your synopsis you have written tender dated 30/12/23. That's what I'm asking.
So sorry, not it 22. It should be 22.
It should be 22. The petitioner shall serve a certified copy of this order on the respondent number 5. Being the it will be to 5. This certified copy would be served on whom?
Secretary, my lord, issued the order, but secretary was also not made a party.
He is not a party.
Secretary is also not a made a party. Annexure
Two,
E, page 18.
respondent 2.
Respond number two, this is the
No,
government
no.
pilot, not Karbi Anglong Autonomous.
No,
Karbi Anglong-
then that interim order we can't pass.
He has not made the party also, who passed the order.
No, so we have made it.
Annexure D, page 18, order is passed by the Secretary Department of Environment, Forest, Karbi Anglong Autonomous Council.
He's not a party.
Is not a
Then
party.
no interim order. No notice on the paper interim review. The allotment of sand mining area to the respondent 7 shall be subject to further orders that may be passed on the next date of listing. Next para. The Learned Standing Council for the respondent numbers 3 to 6 has submitted that as per the provisions of rule, which rule? That appeal,
Appeal 68.
that under the provisions of Rule 68 of the Assam Minor Mineral Concession Rules, 2013, provision for appeal is provided for. And in this connection, it is submitted that in respect of Karbi Anglong Autonomous Council, the council has designated the special secretary,
Special Principal Chief Conservator of Forest.
as a special chief conservator of forest.
Principal Chief Conservator of Forest.
Pardon me,
Special Principal Chief Conservator of Forest, Karbi Anglong.
Karbi Anglong.
Annexure 16.
Huh?
Annexure, page 16 is the link. It was
Yes.
forwarded to the Special Principal Chief Conservator of Forest.
16.
Page 16.
Acha, principal secretary,
Special-
Karbi Anglong Council.
Special
Oh,
Principal.
acha, special principal chief secretary, conservator of forest, Karbi Anglong, Diffu. As the appellate authority, full stop therefore, the pendency of this requisition shall not be a bar for the petitioner to file an appeal before the said appellate authority. And we inform the court about such filing. If so advised.
Otherwise, divisional forest
Will
officer,
file appeal if so advised and then inform the court.
otherwise divisional forest officer who has passed the order of cancellation, at page 22 is a party.
No, the settlements are by the superior authority.
But he has already communicated.
LOI is by the DFO,
LOI is from DFO.
but the subsequent letter is by the secretary.
And Special
therefore,
Principal Chief
secretary is
Conservator of
the-
Forest forwarded to the Secretary. Page 17.
But I will be allowed to make a party.
They are not
Okay.
made a party.
Before on the prayer made by Learned Counsel for the petitioner is permitted to implement the appropriate and necessary party in this writ petition, which shall be done in the civil pending section, and thereafter the central registry shall be and consequential correction shall be done in the central registry. Okay. I'll take a break and come back.
Sir, 51 to 53.
My lord, I have gone through the instruction that my learned friend has produced. On a cursory look, cursory glance, the action maybe, my lord, may appear to be justified, but I will implore that your worship will go a little bit quickly, by the instructions. And read the instructions, none of the relevant portions. The worship may come to, my lord, the second subject matter. With regard to the issues raised in the writ petition and also has brought to our later cited above, the following facts are highlighted. The requirement of supply experience as is included in the writ document original dated 19/10/2023 on the basis of the decision in the departmental bid committee meeting held on 16/10/2023, which was based on clause 4.2.1 required minimum experience. that of the standard bidding document published by the Finance Department, Government of Assam. Now, my lord, they say that on there is a, my lord, notification. Thereafter, your worship would be kind of 2 paragraphs. I will read, my lord.
Specifically, if you come to paragraph 8,
What I am on is that, my lord, this standard bid document, according to them, my lord, was issued on, my lord, 23/9/2023. That your worship will find that clause 2.
yes.
23/9/2022. Now, when this, my lord, NIT was issued on 29/9/2023, this was already in existence. But then, my lord, they had given the conditions in the procurement notice in a particular manner, which has given me some right. Now, if your lordship kindly comes to your worship is referring to clause 8, my lord, the opportunity.
I just saw, yes, that to give an objection, so for rectification or others, there was a time given.
My lord, we didn't have any grievance against the, my lord, the e-procurement notice.
Okay.
We didn't have it.
I get it.
What they have done, my lord, if your lordship kindly comes to clause 1, subclause 2, 4.2.1 and subclause Roman 2 of the SBD states, the manufacturer should have valid manufacturing license and experience of manufacturing and supplying of at least for 3 financial years ending 31st March 31st March. I fulfill that. Then further it may be mentioned that by Government of Assam Finance Department notification dated 23/9/2022, the standard bidding document was notified for various procurement entities as defining section so and so so and so. 3, based on the bid requirement of this SBD, the modification to the original bid document to the extent provided in the revised clause of the bid document was effected and published in the corrigendum dated 19/10/2023, which is under challenge. Now, your lordship may come to clause 6. Further, the SBD stipulates experience of manufacturing and supplying of at least 3 financial years in respect of the quoted goods. In the instant bid document, the supply experience has been considered within last 5 financial years, thus broadening the scope and opportunity for the manufacturer to submit their supply experience. I also fulfill this, my lord. My case hinges, and the difference with them is that, my lord, this experience of the manufacturer of supplying, even if, my lord, I give away the point that, my lord, the bid document was subsequent to the SBD, and that gives me right, even not considering that, your lordship will find the requirement is only of supplying. I am a supplier, my lord. I am a manufacturer. I also have this, my lord, experience of supplying, but not to the, my lord, government departments and PSCs. And that requirement is not there in the SBD. If we take or accept, my lord, the entire thing as correct, my lord, even then, my lord, I fulfill the requirement.
Because if you manufacture, you sell.
Yes.
If you sell, you supply.
Yes, my lord. I have got the sale license. I have got the supply license for the government of Assam. I am supplying. But only thing is, my lord, not to the government and PSUs. And the SBD, my lord, does not have that requirement. It's not that, my lord, we are disqualified only because, my lord, we don't have the experience of supply. We have the supply experience. But, my lord, this, my lord, requirement of supplying to the government departments or PSUs, that is not there in the, my lord, SBD, if we go by this.
Yes, Mr. Chaudhary. Now there's one, Mr. What do you call, one Chaudhary against the other. Now, what do you have to say?
Lordship, first of all, this corrigendum was issued on 19/10/2023, and it clearly laid down that if anyone has got any grievance, he can no. It was there after the corrigendum, which now has been placed at the supply portion project to the government or any other undertaking. And in the NIT lawsuit, it was also provided that if they have got any grievance, they could have gone before the appellate authority. It's enough time was their lawsuit on 1910.
Where is that clause in the NIT corrigendum?
Corrigendum. Lordship may turn to page 104. Lordship 105. Lordship, it will be annexed. First one, Lordship, the last date of submission of bidders' queries for clarification or suggestion, if any, on the bidding document for the consideration of the departmental bid committee evaluation committee of the program entity is extended till 4/11/2023 up to 5 p.m.
Okay.
And Lordship, they didn't approach till date. They have
No,
not
but
approached the
you see,
authority with regard to their grievance.
Mr. Chaudhary, senior counsel is saying that he is not agreed by that.
Yes, Lordship, now the supply part he is to the government authorities.
But where is that condition to government authority? Where is that in the tender?
The original tender is not there in the corrigendum, my lord, in the SBT also, my lord, as quoted by them, is not there. And your lordship will kindly say there was my lord, a meeting was held, there is a mine which has been annexed to the repetition, where, my lord, by which they want to justify the corrigendum, that I'd like to draw your lordship attention to. My lord, page 110, madam. Decision of the DBC, Departmental Bid Committee, on issues, suggestions received in writing from the aspiring bidders on e-bid or manufacturing agricultural items. Then your lordship may kindly come to page 113, which is relevant for the issue raised in this. Experience of manufacturing. Based on this decision, the corrigendum position. Experience of manufacturer, the first column is, my lord, bidder's suggestions. Second column is the, my lord, original content of the bid clause. And third column is the, my lord, decision of the DBC. Now, original content your lordship will find, if the manufacturer is participating in the bid, in that case, the manufacturer should have valid manufacturing license of the quoted items and also should have experience of manufacturing the quoted items 3 times the quantity as specified for each item in the bid document schedule of requirement for the last 3 financial years ending 31st March.
Yes.
Relevant document to be submitted. Then, my lord, decision on the last column. Supply experience of manufacturer is to be 30% quantity of the quoted item to any government department. Where from has it come by? This is my query. That is not in the SBT. The only purpose may be that some of the, my lord, my dealers or other dealers, they think that let us have the, my lord, the slice so that the manufacturer is upstage. That is a mechanism that has been, my lord, that has been incorporated here. As BD does not say, the experience of 5 years I have.
No, that you see, after the decision of DBC
My lord.
on taken on 29/9/2023, has that what do you call? Is that condition modified under the corrigendum? Where is that corrigendum? That's what I am asking.
103, lordship.
103.
Which is under one particular clause is only under by the original paragraph page 102, relevant, my lord, page 103.
103 lower portion of the right hand side.
Manufacturer should also have experience in supplying at least 30% quantity of quoted items to any government department undertaking entities PSUs within the last financial year. This is the only part, my lord, I am agreed with. I fulfill all the conditions, even I fulfill the conditions of the SBD. And there is no justification in the minutes, my lord, why that has been incorporated.
What is the date of opening of the tender?
Lordship, the
Last date
2011.
is,
2011.
2011.
Monday, Lordship.
Monday is the, my lord, last date of submission that your lordship will find at page 106. But my lord, hard copy to be submitted on 21st. So they cannot open the book, perhaps. That your lordship will find that, my lord, page 105. Last date, the clause 2 at page 105. Last date of submission of bid is extended till 14/11 to 23 till 5 p.m. The last date for submission of hard copy bid within 3 days. Bid opening date is, my lord.
So
16
what is the item? Micronutrient.
My lord, in the first reputation, it is micronutrients, second reputation, biofertilizers, and the third reputation, pesticides and weedicides.
Please say it again.
First item, my lord, 6588 is micronutrients.
Second is
Second is, my lord, biofertilizers.
third is
Pesticides and weedicides.
pesticides and weedicides.
And the, my lord, repetitioner is same in the first and second item. My lord, a different repetition.
Pardon me?
My lord, first repetition and second repetition is by the, my lord, same repetition. Third is a different.
Different represent.
Therefore, my lord, my prayer will be, your worship will allow us to participate. I fulfill all the other requirements, except the government supply. And they can produce the, my lord, SBD because their quotation, my lord.
No, you see, is something more, which I'm thinking. You see, we can't pick and choose you and allow you to participate, because if participation is permitted, we have to permit all the manufacturers.
True, my
Now, and allow me this, Lordship, it's difficult because it's a e-tender, everything is done in the portal itself. Lordship.
But then you have to devise a means, because if it is contrary to the decision is contrary to the finance department guidelines, then he has to be permitted.
And secondly, Lordship, the Rabi seasons are there, it has to be distributed by the first week of December to the farmers.
No, correct. That's not.
You advertise it in September, keep on extending it. Although they had issued the advertisement in the end of, my lord, September. They extended it themselves, and they say, my lord, it is a.
Yes, Lordship, there was mistake. It was brought to the notice in the previous meeting. So reasonable time has to be given to the all prospective buyer. Leaders, Lordship.
So you'll have to say that you'll have to extend the time for 1 week, allowing participation by the manufacturers. It will not cause much delay. And the finalization will be subject to further orders of the court on the next date. We'll issue a notice of shorter time, either 28th, 29th, 30th of this month. When do you want?
Lordship may take it upon 22nd, Lordship. I will file the application by 21st.
22nd.
Yes, Lordship. Subject to Lordship.
Okay. But Mr. M.K. Chaudhary, Senior Counsel, Learned Senior Counsel, assisted by Mr. M. Sharma, Counsel for the Petitioner. Also heard Mr. V. Chaudhary, Standing Counsel for the Agriculture Department, appearing for all the respondents.
Yes. Yes.
Next paragraph. Pursuant to order dated 15/11/2023, the learned Standing Counsel for the respondents has produced a copy of instructions dated 16/11/2023 received by him from the Director of Agriculture, Assam. Full stop. With regard to the incorporation of clause in the tender in question by way of a corrigendum requiring experience, requiring the manufacturer of the supply items like micronutrients, biofertilizers, pesticides and weedicides, to have experience of selling its products to the government departments and PSUs, it is submitted that the said decision was taken in the departmental bid committee meeting held on 16/10/2023, and the said decision is also based on clause 4.2.1 within bracket required minimum experience bracket closed, that of the standard bidding document published by the Finance Department, Government of Assam. Full stop. The relevant clause 4.2.1 and subclause within bracket Roman 2 of the SBD, i.e. standard bidding document, as per the said instructions, states inverted commas. Yeah. First of, accordingly, it is submitted that based on such requirement, the revised clause was inserted in the tender by way of a corrigendum dated 19/10/2023. Full stop. Opposing the prayer for interim relief, the learned standing counsel for the respondents has submitted that the inputs for which the tender was issued are all necessary requirements for the agriculture for the agriculturalist, as the first week of December is the sowing season, right?
Yes.
And therefore, it is submitted that public interest is involved in early supply of the tendered items. And it is also submitted that all the prospective bidders were granted time to file their suggestions or vent their grievances till 4/11/2023, but the rate petitioner has not availed the extended time to give its suggestions to the respondent number 2 in respect of the amendment to the bid document pursuant to corrigendum dash Roman 1 dated 19/10/2023. To sowing season, sowing Rabi season, RABI, Rabi season. Full stop. Next paragraph. In view of the nature of grievance raised in the present writ petition, comma, issue notice returnable on 22/11/2023. Requisite extra copies of the writ. You have given it to him extra copies?
Already given and we'll give more, madam.
Ah. Okay. Extra copies of the writ petition has already been furnished to the Learned Standing Council for the Irrigation Department. You give extra copy because otherwise he'll give one extra. We'll just say one extra copy of the writ petition will be provided to the Learned Standing Council for the Irrigation Department in course of the day. Next, heard both sides on the prayer for interim relief, which is opposed by the Learned Standing Council for the Agriculture Department as indicated above. Next, having regard to the hearing before referred, clause 4.2.1 and subclause within bracket Roman 2 of the SBD. The court finds that the standard bidding document published by the Finance Department, comma, in the said clause contains no requirement for supply to be made, experience of supply to be made. The experience of supply would be counted only in respect of supplies made to government departments and PSUs, by excluding supplies made to private in the open market. Comma, the court is inclined to provide the respondent authorities shall permit the petitioner to submit its online bid. It's an online bid. What is the last date of bidding?
20.
20. And if submitted, comma, the bid shall not be rejected on the ground of lack of supplying experience in the government departments and government and state-owned PSUs. So, however, the moreover, the respondent authorities shall also provide information in their website permitting other manufacturers to participate in the tender. First off, this what do you call this? Finalization of tender is not taking place before 22nd.
Lordship, on 28th, it will be submitted. Thereafter, within 3 days, hard copy is required to be given, and
We'll give hard copy also.
just the
Online copy, online copy along with other requirements of the submitting tenders. As the opening of tenders
Lordship,
is
it's 21st, Lordship, may kindly pay us 107, Lordship.
107.
The opening is 21st.
21st. So you are submitting hard copies by 23rd. That you will not be finalizing on 21st.
Lordship.
It appears from page 107 from actually E to the rate petition within bracket corrigendum Roman 3 bracket close dated 9/11/2023 that the bid opening is scheduled on 21/11/2023, but the date of the court is inclined to provide that the finalization of the tender
Subject to.
no, what I'm trying to say is that I'm not getting the word. If he's what you call, if he's the lowest bidder, then you will not finalize it without the without that. But if it's not the financial lowest bidder, if the manufacturer is not a lowest bidder, then you can finalize it. That's what I'm trying to say.
Fine, my friend.
It is provided that in the event any manufacturer is the lowest bidder, the bid shall not be finalized till 22nd 11/2023. First of however, if in the process of opening of tender, bidders other than manufacturers are found to be other than manufacturers having no experience in supplying to government PSU, government departments and PSUs are the successful bidders, this order shall not be a bar for the respondent authorities to pass appropriate orders.
That order, that will be subject.
Huh?
That order is subject to the final result.
No, if not required, because if you are not the you are already out. That's why. List on 22/11/2023.
I was just asking my client, whether you have got so enormous supply, why are you not supplying to government departments and?
No, there are people who don't supply.
Yes, because the
Because
payment
because you see,
payment is very difficult.
no, not that. But there are many reasons. Because during my college time, I was also doing business. But this the experiences were not good at that point of time when the blood was young.
Maybe the same thing.
Huh?
It's now also for us.
No, I don't know. By passage of time, people change. But at that age, when I was in a college going student, what you call that patience was not there. So no government supply at that point of time. Friends, you see, those were very good days. I remember those very passionately because of a different reason. When I was in college, many students, co-students of my college were small suppliers in various departments. They would do a business of 10,000, 20,000 and were very, very happy. The small time, what you call departments, some paper supply, some pencil supply, pen supply, which my friends were doing, and they were very, very happy because they could earn. It's not a question of quantum of earning, but it is a question of being engaged. But now with this, what you call large supplies, replacing the small supplies, all those friends who were earlier busy are not so busy now unless they are into very big, what you call supplies. So therefore, what you call the satisfaction which some of my friends have to do small supplies, that I have seen is lost.
no longer there.
It's no longer there. It's that satisfaction that people are engaged. Now, they are not having government job, but they're engaged in some sort of activities. It was a pleasure for few of my friends to be engaged. So that is a part I miss.
Highly applied.
51, 52,
51, 52, same.
and 53.
53, same. I've just clubbed it together. These three portions I've added together. Just one moment. The petitioners had produced a certified copy of this order before.
Lordship, Director of Respondent number 2.
Before the respondent number 2, to bring the order to the notice of the said authority with a copy to the learned standing committee for the Agriculture Department.
1 minute, just a second. You can mark it.
Yeah. 56. Yes.
55.
Oh, 55. Huh.
Outside, I think 28.
28.
Too much. I will go on that. One item, I think 28, I want to object it to.
28.
From the outside also.
Okay. This is admission. Will take some time. You want to do it at 2 o'clock.
I don't develop highly available.
Huh. Okay, then 2 o'clock. Okay. 28 at 2 o'clock. Item 55. I'll issue a notice here.
Kindly see one.
I'm not issuing an interim order because you see this closure order is of March.
Yes,
We are now in November.
yes, but they applied for the relevant requisite documents.
No, I understand, but you see, closure order is of March. Now we are in after 6 months.
The person has submitted those documents before the respondent. Can you see page 200?
No, you see, now in your organization there is a what you call this is a stone crushing unit.
Yes.
Correct.
Yes. At the relevant point of time, some documents were so.
It's okay. You see, since that order is of long back, interim order at this stage is not called for, Mr. Chauhan. What you are trying to show it to show to us? What you are trying to show?
After passing of the order, they obtain the relevant requisite the documents.
Where is that?
All documents annexed in the document.
Where is the impugn order? Where is the impugn order?
190.
197.
97.
As part of the direction of the honorable court of PI.
Pardon me?
As per direction of the honorable court in a PI, page 197 was it?
Now, what document you have collected?
It's a document which is required for deed of religion. Every requisite document, as per the provision of some stone crusher establishment in 2013. All relevant documents.
No, that is, you see, that is a post decisional. You'll have to apply before the authorities to renew your license. Where is that application?
Kindly see page 200.
Page 200.
Yes. Before that. All the documents, relevant documents, requisite documents will be submitted by the petitioner before the authority. Despite of that, nothing has been done. Are allowed to the petitioners to operate.
No, stone crushing establishment.
Yes.
Who is the licensing authority?
The closure is, kindly see one thing, page 198, last paragraph, last line, friends. These industries are moreover directed to submit to the office of the undersigned, that is deputy commissioner. All requisite
no.
clearances, NOC and permission as per relevant rules from.
No, you see, Mr. Chauhan, please try to understand. The orders are passed in PIL. The district commissioner in the capacity of a district magistrate
Yes.
exercises certain powers. So it for the purpose of law and order or environment, it has closed your industry.
Yes.
And it says that if you have any document, show it to us.
Yes, sir.
Now the document you are produced is post
Yes,
decisional
subsequent-
documents.
subsequent.
So subsequent documents there, the deputy commissioner is not the person to open it. It will have to be considered by the department who is the authority in issuing licenses.
My lord, then, my lord, petitioner may be allowed to, my lord, to submit all the documents before the.
Definitely, you have a right. It's no question of allowing us.
Not accepted,
No, no.
not considered.
You see, you are right to apply for a license. Is your fundamental right. Can I stop it by saying no? You do it.
I have already applied, my lord, already obtained my.
No, no, no. You apply before the competent authority for renewal of the license.
You have to approach the divisional forest of the Odalguri. And also we are acted as per direction of the honorable court.
No, I understand. When you have showed the PIL order, then I recollect.
80 onwards, kindly, for the time being, my kind of.
No, no. You see, this document at page 80, whether this is appropriate or not, it is not for the Red Court to decide. Whether this document is sufficient for you to start your establishment is for the competent authority to decide. On that day, you see, you have, Mr. Chauhan, you have made a prayer that please quash the order of closure. On the day when the closure order was passed, you did not have the documents. So therefore, it can't be quashed. Now, what you require is that if you have a document, then you have to ask for the reopening of your establishment.
Some documents over there, my current see page 80, my. This document was issued on 29th and 22, my. So before, my lord, passing the order. Page 80, my lord.
Page 80.
Yes.
So is this document good enough to without any other document? Is this
Consent to operate. It is passed by my lord, the pollution control board.
then why do you say that you have collected the other documents?
Some documents, some of the. documents.
Aha.
Partly there.
Some
You see,
documents
you have a lawyer's license by the Bar Council. I ask you where is your graduation degree? You can't show me. So despite having the lawyer's license, I don't permit you to appear before the court in this court hall. Let us say it's a worst example. My examples are never good. So this is an example that I ask you suddenly, where is your graduation degree? You can't, you are given time, you can't show it. Now, I don't allow you to appear in the court for some reason, which may be good or bad. But if you have a what you call the graduation degree, the deputy commissioner has given you time to show it. At that point of time, you did not show it. Now you say that you have now passed out the what you call graduation in MA, MSc or whatever, BA, BSc. Now you have passed out. But the requirement of LLB is that you must be a graduate to have an LLB degree, or otherwise you will be a 5-year degree course. So you get a composite degree and then you can apply. So you see there are two different circumstances. First is a pre-compliance and the second is post-compliance. If it is post-compliance, the authority who is entitled to give you permission will take a call that now you have it, now you can exercise jurisdiction. But to quash that order, you have to show that on the day when the order was passed, it was inherently wrong. That you can't show.
Some documents have to
So, no. You see, appreciation of the document, Mr. Chauhan, doesn't help me. If it is a post-decisional document.
It's 2/3/23.
Then lordship.
So just tell me one thing. This page 80 document, is it sufficient for you to operate?
Not only that.
Then
NOC
why should I read the document?
And 83, my lord.
You say 8300, you let us say 1000 documents are there. I don't want to read the 1000 documents. But are those 1000 documents which are predated the closure sufficient for you to run the industry? That is the only question I'm asking. If it is not, you go to the authorities. We can't quash it. But if I pass a reasoned order and then refuse it and dismiss it, it will be worse for you. So please don't permit me to what do you call, dismiss your writ petition on that ground. We just close it with liberty to you to approach the authorities and get a and they will exercise their power to renew your license. Because if I close it, your opportunities will be lost. Heard Mr. R.S. Chauhan, Learned Counsel for the petitioner, as well as Mr. K. Gogoi, Learned,
I'm paying for S1 5 and 9 lots.
for one, CGC.
My brother.
Okay, for one, Mr. Datta A.K. Datta, and CGC appearing for respond number 1. Pollution Control Board, you are there?
S Puro is there on the east. There was
Oh,
some
okay.
difficult
Okay, Mr. S. Barwal, and leave petitioners, huh? So we'll go one by one. One is Union of India, Mr. Datta. 2 is Industries Department. You are there, and name. And Kalita is standing also for the Industries Department, appearing for respond number 2, 2 and 7. Ms. R. Borobora, then standing also for BTC, appearing for respond number 3, 3, 6, and 8. Mr. S. Barwa, standing counsel for the Pollution Control Board, respond number 4. Government Advocate.
I'm for
Oh,
5 and 9
Mr. K. Gogoi, Additional Senior Government Advocate, appearing for respond number 5,
and 9 lots.
5 and 9. Now, Agriculture, Mr.
Agriculture is seems the BTC.
You'll appear.
No 8 lots.
Okay, so she will be for 3, 6, and 8. And 9, Circle Officer.
9 lots. Yeah,
You're there. Okay, 9. Next, Peta. The case of the petitioner is that by virtue of consent to operate obtained from the Pollution Control Board, how the petitioners are operating their respective stone crusher unit. However, the Deputy Commissioner Udalguri, now District Commissioner Udalguri, by the impugn order dated 16/3/2023, under memo number UMG-6/2020, part PT, /4 to 9, /6208, on recording its satisfaction with the inquiry report and the emergent nature of environmental impact, ordered closure and sealing of the stone crushing unit of the petitioners operating at Gorubandha, Gorubandha village under Mazbat, MAZBAT Revenue Circle. First off, accordingly, the aggrieved petitioners have assailed the said impugn order by filing this writ petition under Article 226 of the Constitution of India. First off, the Learned Counsel for the petitioners has submitted that although the petitioners had several permits and no objection from various authorities, only few documents were lacking, which were subsequently procured by the petitioners, and they now have all the requisite documents to operate their stone crusher units. In this regard, on having considered the submissions made by the learned state and departmental council appearing for the respondents, This court is this court, without adjudicating the issues involved in this writ petition, is of the considered opinion that as the petitioners project that they have the requisite documents to operate their stone crusher units, it would be in their interest to permit the petitioners to approach the competent licensing authority under the Assam. What is that rule called?
The Substone crusher,
Assam Stone Crusher
establishment and regulation rules.
Establishment and Regulation Rules, 2013. For renewal of the stone crushing unit license. And in the event such an application is submitted by the petitioners individually, the said competent authority shall consider the same and pass appropriate orders thereon, after considering the documents in its entirety as produced by the petitioners in support of their application. Next, according to this, without adjudication of the issues involved in this writ petition, this writ petition stands closed with observations as indicated above. Along with the application, the petitioners shall produce a certified copy of this order. Continue at 2. I may be 5 minutes late coming.
Wait to the Lordship. I'm sorry to mention at this hour, my lord. I'm not feeling well. There are 2 items, my lord. One is 34, another is 42. 34 was last occasion, my lord. It was for disposal today, my lord. Can it be fixed on Tuesday and the other item?
Tuesday and Thursdays, this time we are not fixing it. There are already matters posted.
It is
You can give it
fixed for
next week thereafter.
but hearing that because it was fixed for my lord disposal.
Item
Item 34 and item my lord 42.
34 is a 23 matter.
Which are my lord?
Item 34 is a this year's matter.
My lord,
23.
There are some urgency. It is regarding building permission, my lord. So, my lord, if your lordship go through the last order, your lordship will have the same. So there is very much urgency is there.
Okay, then fix it on 30 November
30 November.
30.
We'll
Yes.
say hearing them and
List on 30.
20. 20.
No, we have already fixed matters. There are a lot of fixed matters on these days.
Also, it is rich or not.
No, we don't know. You see, I can merely work to my best of my ability, but I can't promise that every matter listed in the board will be disposed of.
Small matter, my lord. Can we take
No,
it
no.
up?
You see,
Can it be taken up at 4 o'clock?
today we'll try to take up. Be there.
At 4 o'clock.
No. You see, I am assuring you that 4 o'clock will try to take up. I am not what you call the assurance is not that I will take up.
Yes, my lord.
Correct.
I'm not feeling all that.
If the matter which is which is coming in the board next, we may take up the entire day. We don't know. So we are just we are saying yes, but we are not promising anything. If you permit me to work, I will be reaching there. Otherwise, if we deliberate, we will not reach there. Yes.
Supplementary item 56.
Yes. Your fight in the writ court. Your fight in the organization is spilled over to the writ court.
I understand. The place where I'm put now, submitting it was things are not quite present. There was a Shuffle as to who would be the, I mean, between the chairman, vice chairman as to whether they would be or not. Honorable Court directed the registrar to take a call, they decided registrar to take.
You are challenging the order dated 7/11, right?
I'm coming, Lordship permits me.
Mhm.
So far the chairman, vice chairman is concerned, High Court directed the registrar to take a call, appeal, registrar to take a call, and the chairman, vice chairman are there. As to put the secretary between respondent number 6 and other person, again, High Court directed to take a call, the authorities to take on, and the present respondent is the secretary. So office bearers are there. Now, insofar as settlement and official is concerned, it is not settled in the chairman's name, vice chairman's name, or secretary's name. It's a settlement for the society. Similar, so far as collection of revenue is concerned, it is to be done by the Mohoris appointed, collected, according to the officials of auction. It comes to the society, and then the revenue is paid. There's a process of doing it. Now, since there were some disturbances, in-house disturbances, the Cooperation Department took a call, also, Honorable High Court also intervened in the matter, and things are restored to there. But order impugn tacitly gives a right of collection of revenue to the secretary. What I am on is that no official, no director, no one has the right or can be granted a right. So therein occurred a jurisdictional error by the statutory authority, by state authorities concerned. Now,
Who is the person responsible and liable for revenue to the state?
Pakistan proceeding. I thought
No, 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 not Bakisha proceeding. I'm just asking in a given case, in a fishery, who is the person responsible of paying the government revenue?
it is the board. The board who runs. In absence of the board, it's the departmental officer who would run the show. Revenue, if not paid, then two things. 8E of the fishery rules, risk sale, or Pakistan proceeding under the Bengal Act. Now, what I am on is that settlement is not with an official, chairman, vice chairman, secretary, whosoever, or the board of directors. They may be there, they may not be there. It depends on the circumstances. Satisfy the Provision 39. May I begin? Now, this is a case where there is a discord between the authorities itself. The discord might not find that page 46, where the additional deputy commissioner concerned, in very strong words, opposes to this thing. Help it on a line against the personal concern. My submission is not against the person concerned, whether or not he is a good man or a bad man, or he has done some mistake before. That we can sort it out in the cooperative department and all. But so far as the impact of the order is at page 48. When I'm put as the chairman of the society by an order of the registrar on a hearing of appeal after the election of the Honorable Court, he writes to me in substance, if I may say, give back the articles, give back the money, give back this, give back everything. Page 48. This is a fallout of the order. Therefore, we have challenged the root of the order. May I read 48?
48.
That's the effect of this order. 48. The SMS is at page 50. Vernacular, if I may read, or the English version. Page 48, if I may read. You hereby urgently made known that as per decision of the board of directors, you have not handed over the articles of the society, such as store, weighing means, scales, tumbler, etc., concerning Vijan fish selling card for society. Although you informed certain you have not been heading towards the notices of the society. On the other hand, you had appointed Mohori since.
So against this order, it would not.
I'm not against this order, in fact, per se.
No, I don't know. You have challenged it.
I have challenged the consequential part that we can always go and press up before the authorities concerned. I am on 45, 44. Point 44, 46 is a consequential order, which action taken. How difficult it has made for every one of us in the society. If the power of collection of revenue is given to a person, man, it is being opposed by the additional deputy commissioner, page 46, if I may be, page 46. It is being opposed. They have a tiff between themselves also.
No, where is that order of 7/11?
44.
44.
44. Apparently, it seems enough was order.
40 merely says that you collect revenue and give it to
Why not? It tangentially bestows the power on the secretary. That's how it comes up. May I read that order? That order.
No, just point out. Don't read that. Just
Whereas
point out.
the third paragraph. Whereas
Huh?
Whereas zonal joint registrar Jorhat has submitted a report dated so and so that duties and functions of president and vice president of cooperative society are different from that of the CEO, secretary of the society under Assam Cooperative Societies Act 1 as defined under section 38 and 49 of the act respectively. And thus they can't discharge the duties and functions of secretary, including collection of revenue. The collection of revenue has nothing to do with the settlement. Secretary is a CEO. Chairman, vice chairman comes in different elected members. Now, collection of revenue is a different concept altogether with the settlement holder of fishery. Now, what is it? In view of the above, District Commissioner Tinsukia shall instruct ARCS Tinsukia to ensure the legitimate secretary to discharge the duties and functions of Secretary of Society as defined under section 49 of the Act, and the lessee society will deposit the revenue timely in government account. With this, all such other government order instructions regarding collection of revenue, that is what I got, of Brahmaputra Part 1, Dibang Nadi Fishery, by so and so, stands withdrawn. Now, may I invite my attention to 46 for it? I'm not against the person concerned, I'm against the post. It need not be anyone. It's a society heading. 46. This is by additional district commissioner, Sodia, to district commissioner. With reference to the subject cited above, I have the honor to inform you that Mr. Vikas Das, as Secretary of Dibru-Danguri River Part 1 Main Saw by Samiti Limited, had defaulted huge areas of government revenue amounting to 3,34,000 and prayed for time to repay the area amount. Despite 2 months' time being given to Vikas Das, he had failed to deposit the area. Only the president of Dibru-Danguri River Part 1 Main Saw by Samiti Limited has deposited an amount of 89,000 from the month of September 2023 after taking over collection of revenue from fishery. In this regard, President of the society has filed FIR in Ola Police Station for misappropriation of funds by Vikas Das, which is under investigation. Therefore, I would like to request you to restrain Vikas Das by an order from the Good End Office for collecting fishery revenue again, as allowing the defaulter to collect revenue again will be detrimental and again the public interest. A demand notice has also been issued to Mr. Vikas Das on 9th of November to repay. This is against a man. I am not on the allegations against a man. What I am on is that the society is suffering because it is a body which takes in the society. Now, if the power is given to a person to collect, difficulties are coming to against the chairman. I was put to power by after a hearing. After Honorable Court said the registrar took a call, the hearing, I came. I am not on my powers. I am saying if the entire thing goes, the society will be, there will be risk sale, there will be resale of the fishery, all things will follow. Even the chairman took pains to deposit some money.
So, Manik, it's a very simple answer. You will find in this, in my small experience I have, every society where there is money, there is fight. In my near my original home, there is a library. Nobody fights for president and secretary. People have to go to door and door with folded hands to make somebody president, somebody secretary, because it's a deficient organization in our society. Nobody is ready to be president. When they see people coming from the this Pustakalaya, people leave their office and run away. They know that they will be made president, secretary, or office bearers. But in every other institution, there is a huge fight. So what we'll do here is that we'll ask the government to take over the fishery. And in the meanwhile, till your...
There is a valid settlement in progress. We have done no wrong.
No, it's okay. We'll say that temporarily stop your fishery, run it departmentally till you settle your in-house disputes.
But in-house disputes were never there. That's what I'm on. In-house disputes were settled. If I may invite my attention,
Yes.
2 pages, page 20 and page 38.
20 and 38.
20 and 38. Settled. In-house disputes are settled. There's no dispute at all. What I'm saying is that government has exceeded its jurisdiction. Page 20.
Okay.
The operative part would be at page 23, after High Court's order. Page 23, the operative part. Also, the third last paragraph, also. Whatever is it? Also, on the basis of the above mentioned reasons regarding non-compliance of the part of the society with the rules and regulations mentioned in so-and-so Act, it can be concluded that the Board of Directors adopted resolution for removal of Vikas Das, that's the 6th respondent member, from the post of Secretary of the Society without the show cause notice of his skill before removal. My opinion, it is arisen from the above that the termination of Vikas Das Secretary,
Now this...
it takes care of the Secretary part. Everyone accepted. And so far as the Chairman, Vice Chairman, page 38. Page 38.
No, it's okay. You made your point.
So I'm only on that. No person may be given that power, no post. It's with the society. Only that much, because the additional deputy commissioner has also intervened in the matter.
Okay, yes, yes, Mr. Sharma,
This part is by the assistant is a cooperative, they may. they have-
yes.
Standing Council of Cooperative Society, Mr. Space, so we'll get the instruction.
No, but this has to be state. This order. What do you call this? 711. Question of legitimate secretary to discharge duties doesn't arise. It will be the society.
Absolutely.
Partial to this logic, we have part is speaking or not.
Where?
Different department. In page number 48 logic.
40,
45 logic.
45, yes.
Here, Lordship, we have taken note of that report, Lordship.
That is the same page, same order he's referring to.
Lordship, we have to accept this procedure was, process was.
45 is that, it's only,
42. He's referring the same order, 44.
Yes, Lordship, we have.
40, 40,
44, sorry, 44.
40. Correct,
This is speaking order.
correct. No, where is, you see, you know the act. Does it give liability to the secretary?
If I know, regarding cooperative society, I have to go through it.
No. Under the fishery rules, the settlement is not under the Cooperative Societies Act. Fishery is settled under the fishery rules.
Yes, sir.
So under,
Regarding this is, I think regarding also this because of being a position, this is between infighting with among them.
no, it's okay. That Mr. Banik has addressed. Now, whatever be the fighting, it is the liability of paying revenue is with whom? That is the question I asked him. That's the question I'm asking you.
Society.
If you are arguing for him, you come here.
I thought it was a question.
No. I have made you sit down. If you are arguing for him, come this side.
Society, definitely society law.
It's society.
Paid by the society. If the society is one lawsuit, then if they have to pay the lawsuit money.
No, it's okay. If the society fails, you take over the fishery.
Then they will be default in the future also they will be default.
They'll be defaulted for some years. You do that, but why can you say that X will collect revenue? Why will collect revenue?
Society will collect it and society will.
Correct. You are absolutely right. Absolutely fair submission. Because so far as Corporation Department is concerned, you have made this respondent 5 the secretary. There's no dispute. You'll have to go by your own order. In fact, this writ petition should have been filed by the state against the order of the what you call this fishery department. The deputy commissioner should have come to court. No. You see the order, page 44. Page 44 says the district commissioner Tinsukia shall look into the matter and take necessary action for timely deposit of revenue. So he'll pay from his pocket and recover. What to do? You recover from the secretary, from this deputy commissioner. Auction is property. Why you are troubling Mr. Why you are troubling Mr. Banik? That's your order. So what to do now?
Lordship, Monday, Lordship. Till Monday, Lordship. It's, I have to take instruction on it. Very new to this.
Monday, deputy commissioner will pay.
Lordship, this part has to be verified, Lordship. I am very new to this department, Lordship.
No,
Class one, Lordship.
no, you see,
Chronic will not suffer for 2 days, Lordship. Just, Lordship may pass any order, just give me 2
in colloquial, what you call terms, we say that poison, whether in large dose or small dose, is same. So if you join the department, you have a share of poison,
Yes, sir.
whether you like it or not.
Regarding instruction for Lordship, then also listed again on Monday.
No, it's okay. You see, but this 44,
Lordship.
how is it implemented, Mr. Bani? Page 44, how is this implemented?
Implemented in the sense that now he's all in all,
Who?
the secretary concerned. He's willing is sort of.
No, where it says secretary. The district commissioner in Sukia shall instruct ACO to ensure.
Earlier paragraph, this paragraph. That's the difficulty coming in.
There are the last, from last paragraph.
They can't discharge the duties and functions of secretary including collection of revenue. That is how it follows. And it is burdened to the deputy commissioner. What we say, in-house fights are over, let us run the show. If we default, consequences to follow. Don't give any person, any office bearer, any responsibility. We would run the show. Third last one.
Where is the order of the writ court? 29/2023, where is that?
This is the 20th of September, page 16.
16. Has AGM been held?
AGM has been held, and now they are not approving on some count. On that reason, a repetition is pending. Notice of motion was issued on 7th, this order comes in. And the 9th, the additional deputy commissioner has also stepped in quick succession.
No, then we state, we fix it on whenever you want. We'll reconsider the interim prayer on that day.
Whether if now no interim protection is granted,
We'll give you protection.
watch it.
But Mr. S. Banik, learned counsel for the petitioner, also heard Mr. P. Sharma, and its standing counsel for the Fisheries Department, appearing for respondent number 1. Also heard Mr. A.J. Sharma, learned counsel, appearing on behalf of standing counsel for the Corporation Department, appearing for respondent number 2 and 3. And Mr. K. Gogoi, learned standing additional senior government advocate, appearing for respondent number 4 and 5. Next paragraph. The affairs of Dibru, D-I-B-R-U, Dangri, D-A-N-G-A-R-I, River, Part dash Roman 1, Mean, M-E-E-N, Samavai Samiti Limited, appears to be a subject matter of multiple litigations. The legitimacy of Sanjay Das and Bikas, BIKAS, Das. When Mr. Banik, when I find you and Mr. Hawk here, both of you. No, it's okay. The overview I have is that what you call the litigation is a sponsored litigation.
He's sitting on the fence.
No,
He is
that's,
not been engaged.
no, that's why I
I
said,
know.
that's why I said, when you two I find in the courtroom, when a fishery matter is moved, the first impression is that it's a setup litigation.
Now the government has stepped in with it.
I don't know,
It's action of the
but
government.
that is the
has-
general impression we are having.
But it's action of the government. you understand?
I don't know, but these two face when it comes to the fisheries. It's a general impression I am having. Did not,
Perfect.
I'm not saying it derogatory. I'm just saying it.
So we tend to
and-
appear in more matters against each other.
Designate of so and so to function as secretary of the of the said society was under challenge in the was in challenge in WPC 5512 of 2023. Post of this court by order dated 29/2023. Disposed of the writ petition by directing the society to make an attempt to decide the said issue prior to holding of the annual general meeting of the said society scheduled on 29/9/2023. Full stop. It is projected by projected through Annexure B to the writ petition that in terms of the hearing before a order of this court, comma, a hearing was conducted by the Assistant Registrar of Cooperative Societies, Tinsukia, on which date was this held?
28, the order of president.
20?
The order of president.
28/9/2023 and 29/9/2023. And as per the hearing report and finding appended thereto, opinion was expressed that the termination of Vikas Das, within bracket respondent number 7, bracket was as secretary, and subsequent appointment of Sanjay Das. Sanjay Das is not a party here.
No, he's gone.
So Sanjay Das, as secretary of the society, is deemed as was deemed as illegal, and in view of the statement made by majority of the board of directors, comma, the Assistant Registrar of Cooperative Societies, Tinsukia, arrived at a conclusion that the respondent number 7 was the lawful secretary of the said society. Even prior to this said writ petition, there appears to be another writ petition being WPC 4083 of 2023. To challenge the order dated 5/7/2023 issued by the Zonal Joint Registrar of Cooperative Society within bracket in charge, Jorhat. In connection with resolution dated 5/7/2023 taken in the meeting of the said society. It is projected that the annual general meeting within bracket AGM of the said society was held on 29/9/2023. However, the resolution adopted in the said AGM, which was sent for approval before the Assistant Registrar of Cooperative Societies Assam, was not approved, was declined to accord approval, which was assailed by the present petitioner by filing WPC 6243 of 2023. And notice in this said writ petition was issued on 6/11/2023. In the meanwhile, the Secretary to the Government of Assam, Fishery Department, had issued a speaking order dated issue order number. This page 44, number from there, dated 7/11/2023. The District Commissioner Tinsukia was directed to instruct the Assistant Registrar of Cooperative Societies, Tinsukia, to ensure that legitimate secretary to discharge the duties and functions of the secretary of the society as defined under section 49 of the Act. Which Act? This is Assam Fishery.
Assam Cooperative Societies Act.
Assam Cooperative Societies Act 2007. And the lessee society would deposit the revenue timely in the government account. And the earlier instructions for collection of revenue in respect of the fishery in questions by letter quoted, two letters quoted therein were withdrawn. And the District Commissioner Tinsukia was directed to take necessary action for timely deposit of revenue of the fishery by the lessee society for the present tenure of settlement in terms of government order dated 26/12/2019. First off, as a fallout of the said direction, the additional district commissioner in charge, Sadia subdivision, SADIYA, Sadia subdivision, inform the Deputy Commissioner, District Commissioner, Tinsukia, to restrain respondent number 7 for collecting fishery revenue again. And moreover, by a communication dated 4/11/2023, the respondent number 7 had also started taking some measures. Next paragraph. Issue notice of motion returnable in. When do you want?
Any date, lordship, if lordship is not giving interim, sort that even after 4 days.
Okay. You're issuing it on 29/11/2023. Requisite extra copies of the writ petition served on the United State and Departmental Council in course of the day. Listener shall take steps in course of the day for service of notice on respondent number 7 by registered post with AD. You sub by Dasti also?
Yes,
As well as by way of Dasti, by routing the process to the registry of the court, and upon service, affidavit of service shall be filed prior to the next date of this day. Next paragraph. On a query of the court, there is no dispute by the learned government advocate, standing counsel for the cooperative society, and the learned standing counsel for the fishery department, that liability to pay revenue to the government rests on the society and not on an individual. Therefore, whosoever may be the office bearer of the said society, if the society defaults, it would be open to the concerned authorities to take an appropriate measure as may be permitted in law for realization of the revenue. But in guise of collection of revenue, the respondent authorities are not empowered under the Assam Cooperative Societies Act, 1949, or under the fishery rules. 2007, under the fishery rules, 1953, to empower a particular person to collect revenue and to make payment. In that view of the matter, the court is inclined to provide that the order dated a number so and so, page 44, dated 7/11/2023, should not be construed by any authority so as to empower any particular person to the responsibility of collection and timely deposit of revenue, and these issues should be left to be decided by the said society in accordance with their own memorandum of their own constitution of the memorandum. First of how it is made clear that if the society, petitioner society, defaults in making payment of government revenue, it would be open to the respondent authorities to take an appropriate measure as may be permitted in accordance with law. First of the petitioner shall produce a certified copy of this order before the district commissioner. Which place? Tinsukia, assistant registrar of cooperative society. Tinsukia. And only 2 people. Not to the fishery.
They have settled it with us. Technical difficulties.
Okay, these two people. Okay.
With the
Next
formal-
paper, liberty is granted
When
to
collecting the revenue,
to
we
be-
will advise.
the liberty is granted to the respondents to move this court for modification of their is so advised.
The formal stay order needs to be passed, otherwise this order also remains, although Lord Chief has explained.
Apparently advised already.
No, I'm not saying it because it contains many other things. We are just saying it will not be construed like that. To empower you.
And so far as the last part is concerned, the consequential fallout is taking over charge by.
But they are running the fishery.
I'm not-
No, that is for the society to decide. You can always question that.
We will- alright.
Supply item 57. 57.
Yes, Mr. Chakravarti.
It's an application for improvement in the state election matter. Is it tender process, my lord?
Any objection?
Well, I have gone to file objection, my lord. 2 weeks time may be
What is your objection?
They have taken an interim order.
What is the
My
objection?
lord, in this case, I have challenged the writ petition on the ground that without publishing in any newspaper, my lord, the NIT was proceeded, my lord.
Okay.
And my lord, on 13/9/2023, stay was granted, my lord. So, my lord.
Yes. So how would the impediment change alter the position of the petitioner?
Well, I may be allowed at least 1 week time to file objection, my lord.
No, it's okay, but you tell us a ground.
My lord,
You see, you have been served with a copy. It's an impleading application.
on 14th, they have filed the application, my lord. Now, the contention in the application that I have hidden some material facts, my lord, which is absolutely not correct, my lord. On 13, I filed the writ petition.
You see, those may be a contention of yours, but we are dealing with an impleading application.
Apart from this, my lord, he is not necessary as per my.
Okay, it's very simple. I'll be dismissing this application. Correct. But I'll say that no order whichever been passed in the writ petition will affect his right.
The my lord, already there in interim order, my lord.
It will not affect him. You have the interim order, stay with it. But if somebody comes and says that I am an aggrieved person and you have objection to their impediment, that means you don't want that interim order to be implemented on him. You see, the basic understanding which I have is that an order of injunction would bind only those persons who are a party to the list. If a person who is not a party in a list makes an application for being impeded and you are opposing it, that means you don't want that interim order to affect him prejudicially. That is the simple thing I understand.
Interim order, my lord, was passed not to make settlement to any.
So therefore, if any person is a tender, he is an aggrieved person.
I have challenged and the tender itself, I have challenged, my lord. That was not.
Where do you find this legal position that if somebody challenges the tender, no party can be aggrieved? Show me an authority. We give you not 1 day time, we'll give you 1 year time.
No.
But if you fail, we'll impose a cost of 10 lakh rupees on you.
I pray to your lordship to file an objection. It's up to your lordship.
I'm not on that. You are arguing a position. You are arguing a proposition. You see, we expect that the lawyer, when he is arguing, will tell us the correct position of law. In a tender, there cannot be an aggrieved person. Just show me an authority. You want 1 day's time, I'll give you 1 year's time. But we'll impose a cost which will be payable by the lawyer, not by the client. 10 lakh rupees as cost if you can't show me the authority, because we don't expect the officer of the court to make submissions just in air.
No, I'm not making anything in your mind.
No, take responsibility. You see, take a responsibility. Either you say that what you are saying with conviction, you are right. Legally, you are in the right footing. And number two, you can also contest that the proposition which I am thinking is horribly wrong. I don't want any lawyer in my court to be weak. If you have an assertment, you have a right to speak with fullest of the courage and sustain your argument. You see, I was groomed up in this bar. Had I been not given an opportunity of arguing, I would not have been here. I was once a member of the bar. So it's not just because I got an opportunity, I'm here. So I'm also giving that same treatment to you. If you have a point, please argue it completely. No issue with that. So either take responsibility that, okay, the interim order will not affect Mr. Chakravarti. We are dismissing his application right now here without your objection.
No, I'm not saying that his petition may be disclosed.
No, 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 not your writ petition.
No, no.
His application for
I'm
impleading.
not saying that we-
So therefore, you see, number one, you're not taking that responsibility also. Number two, you're saying that, the second question I'm putting to you is that, how will his impleading materially affect you? Question of objection will come, no problem with that. If you can show me that you'll be materially affected, we'll give you time. Not 1 day, we'll give you 7 days. There's an interim order, there's no urgency of Mr. Chakravarti. But tell me one good ground to adjourn the matter. If you give me one good ground, I'll give you time.
I leave to your lordship.
No, don't leave it. Don't put it on my shoulder. I have many strange thoughts. Have I ever stated in the court that I am infallible? I can make no wrong, or I can do no wrong. I have never stated that. I may be wrong. Many of my orders go to challenge before the appropriate forum. Many are set aside. I am conscious of that fact. I'm not infallible. Will you give me one good ground? We'll give him time till Tuesday. Let him implead. Give his objection.
One second, I'm taking. In this case, I have enclosed an order by which, out of the NIT procedure, I am the highest bidder. Without including me, he has taken an interim order. He is saying that, my lord, I am not.
Where is that? Where is that?
Petition, my lord, I have. After that,
Which page?
Page 9, my lord.
9. 9 of this IA.
9 of the IA. And the highest bidder and.
Just a moment. No, that will not hold good. The reason is that according to the brief I am having, the writ petition was filed on 8th September.
Madam,
So this impugn order is on 11th September.
I'm not saying that at that time I was not a party. And now I am saying that it is being given to me, so I should say something in my petition. What objection may be there, madam?
Oh, acha. Okay. I get it.
I want to say something in the petition.
Then we allow the impleading. Mr. Laskar. IA. Well, Mr. B. Chakravarti, counsel for the applicant. Mr. J. Laskar and counsel appearing for the writ petitioner opposite part number 6. For BTC who's appearing, you are there. Ms. P. Das, standing counsel for BTC appearing for respondent number 1, 2, 3, and 4. And Mr. K. Gogol, and government advocate appearing for opposite party number 5. Opposite party, huh? Number 5. So stop. Next para, the opposite party number 6 is the writ petitioner in the connected writ petition. Next para. By filing the connected writ petition, the opposite party number 6 has assailed the tender process dated 5/8/2023, inter alia, on the ground that the tender was issued without giving wide publication and that it was published in the notice board only on 28/8/2023, which was the last date for submission of tender papers. Full stop. this court, the said writ petition was filed on 8/9/2023, and this court by order dated 30/9/2023, while issuing notice of motion, had passed an interim order to the effect that the respondent authorities shall not issue any work order in respect of the settlement process undertaken for settlement of Dhansiri, DHAN, SIRI, sand and gravel mahal by tender notice dated 5/8/2023. Next, in connection with this interlocutory application, the learned counsel for the opposite party number 6, i.e. the writ petitioner, has prayed for some time to file his objection. Consider this at prayer. Next para, the learned counsel for the applicant has referred to Annexure A to this interlocutory application, which is communication dated 11/9/2023 by the Secretary, BTC to the to the opposite party number 3, i.e. the additional PCCF CHD forest, BTC, by which approval was granted to the comparative statement in respect of the mahal in question for granting mining contract to the successful bidder. And it is projected that the applicant was the highest rate bidder of the said mahal, for which reference is made to document at page 9 of this application. Next, brother. In view of the subsequent communications dated 11/9/2023, which are annexed as Annexure A series to this writ petition, the court is of the considered opinion that as the applicant has demonstrated that he is the highest rate bidder in respect to the said mahal, granting of adjournment merely for the purpose of bringing an objection on record would not serve any purpose, as the court finds that that because of the subsequent development, the applicant is a necessary and proper party to this to the connected writ petition, and therefore he would have a right, and notwithstanding whatever objection may come on record, but the applicant would have a right to express his contention when the connected writ petition is decided. Accordingly, the prayer stands allowed without issuance of notice on the opposite parties in respect of this interlocutory application. Permitting implement of the applicant as respondent number 6 in the connected writ petition. In the writ petition, right? Here it will be Mr. J. Laskar for the petitioner. Ms. P. Das, standing for BTC, Mr. K. Gogol, and additional senior government advocate for the state, and the state, as well as Mr. B. Chakravarti, and counsel for the newly implemented Respondent number 6, next para, in view of order passed today in connected IA Civil 3357 of 2023, by which impleading of respondent number 6 was allowed the registry shall make necessary correction in the cost title of the of this writ petition by impleading the applicant in IA Civil 3357 of 2023 as respondent number 6 in this application. Next para. The interim order passed release stands extended till the next date of listing. The newly implemented respondent and other respondents are granted 2 weeks time to file their response list after 2 weeks.
All right.
Time.
Yes.
We'll
take it.
My driver's inverse another ceremony of father is there. They celebrate in the evening after sunset. And he to reach Krishna Taragi.
Oh, Acha, okay, we'll take it.
That's why it was absolutely.
No, it's okay.
Item 28.
They're trying not to lose your political touch. So you are trying not to lose your political touch.
No, it is not political. My driver's father's ceremony.
Oh, okay.
This is reading Malay, he to Krishna Taragi by 7.
Okay, okay.
For one political Malay, I can leave at 6 also.
Okay.
Here, what Malay, they are taking 3 times. For
Just a moment. Just a moment. Just a moment. Just give me 2 minutes. Yes.
What about draft is ready?
There was a submission made by them on 1810 also.
It is with me, Lordship. We just made an error of printing it on both sides. We just need some time to rectify the error.
No, both sides is permitted. High Court permits it. We are now in paper saving mode.
Then
Who said you have made an
we
error?
don't need too much time. Then we just need
Huh.
2 or 3 days to.
There's a notification of this court. We are permitting it. And that order has been passed in a PIL filed by one of your colleague friends. I thought you should have been knowing it. In a PIL filed by one of your colleague advocate, this court took cognizance and allowed paper saving mode.
In Delhi also, in all courts, it's both separate.
And I personally I've started to do it earlier. I use reuse papers for my notes. I don't use a fresh paper.
Then Lordship, our draft is here with me,
Hmm.
the signed one. Only the annexures we,
Wait, when you are filing it, just tell me the date.
by tomorrow we'll file it.
By tomorrow you'll be filing it. Okay. Mr. R.P. Sharma, Senior Counsel, assisted by Mr. D. Dole, Counsel for the petitioner. Mr. I. Bhattagut, Learned Counsel representing the Standing Counsel for the Forest Department, has submitted that the affidavit is prepared, however it is printed both in both sides of the pages. Stop, as this court has already permitted pleadings to be filed by printing on both sides, the respondents may file their affidavit in whatever mode they want. Full stop. List on. If you're filing it tomorrow, we'll take it up on Wednesday next, 22.
Yes.
22.
By Wednesday, we can be given time.
You do whatever you want, but we'll take it up listing on 22, 22/10, 22/11, 2023. An advance copy thereof shall be served on the learned instructing counsel for the petitioner.
that case, my lord, you may have to file reply. So let it come on 28. There will be
Okay, a week's time is allowed to the respondent to petitioner to file affidavit in reply if so advised. List on 1/12/2023. 1/12.
Supply item 58 and
But
59.
just a query to my mind. I finished the over. I've left it. Dictation is over. I'm just asking. For printing also, you'll have to give a tender. For printing an affidavit, you'll have to float a tender again.
No, your lordship, it was.
No, you said that you made a mistake
Yes.
of printing it on both sides. Supposing you have to print it on one side, then perhaps your department will have to issue a tender again. Printing tender, no.
Lordship, that cost is borne by the chambers.
Huh?
That cost is borne by us.
Okay, so then what was the difficulty? You sought an adjournment on that ground.
We just received it yesterday.
No, it's okay.
no, my lord, they
I
have.
understand it is, you have received it yesterday. But how much effort does it take to print out in a single page? So
Lordship, that
next time, don't,
signature is not there.
please, you see, before you address the court, please formulate your, articulate your arguments in advance. Because when we were young juniors, we found there are lawyers, I'm telling you because you are the future. We are passing away, fading away lightly, but you all are there to carry out the work. Please articulate your arguments beforehand. We had seen lawyers when arguing, when they will raise hands here, that is also an rehearsed, that hand will go up to here, not here. We have seen those days where very articulate arguments were advanced. So please take responsibility of what you suggest, because otherwise you will get people like me will make very sarcastic remark, very politely, very sarcastically. Correct. So please be cautious always. You make a statement, it's okay. But when you admit that this is a mistake of printing it on both sides, so rectification of that mistake costs 1 rupee a page. You are cutting a sorry figure when you make that statement. Correct? Don't do it. Because I read every word, try to understand every word uttered. This is just an advice to you.
You support him, my lord.
Huh?
Because they already got the signature.
No, that's
on
okay,
both
but
sides.
these are young people. We have to groom them up.
So I want to
If they may make mistakes here and there, but we'll have to tell him.
the signature, my lord, otherwise they would have filed it.
Correct. Next time, articulate your argument in advance. Even if it is a prayer for adjournment, it has to be a rehearsed prayer. Don't cut a sorry figure. Correct. It's just an advice. Don't take it in a bad sense. It's only for grooming you up. In Assamese, we call it hekle hike. So this is one of those probable statements. Correct.
58 and 59.
Yes, your button on record.
My lord, we have filed an affidavit also.
Okay, then we close this matter. Where is the document?
My lord, at page
401. Okay,
395, ma'am. 395.
401 is the one.
Yes, 401 is the one.
Okay, then we accept it. Just say, Mr. S.P. Sharma, counsel for the petitioner, and Mr. B. Chaudhary, standing counsel for the.
Respondent number 1 and my grandmother, Mr. Pathak, is appearing. Mr. K.P. Pathak will appear.
Oh, Asha, for respondent 1 and Mr. K.P. Pathak, standing counsel for respondent number 2. Full stop. This matter was listed at the instance of the court as the document relating to the registration of the petitioner firm in the office of the registrar of firms and societies was not available. First, the learned counsel for the petitioners, by filing an affidavit, has brought the same on record. First off. Next, as the hearing has already concluded on 16/11/2023, delivery of judgment is reserved. Yes.
Deep.
We just see you.
Did I see you?
To item 11 and then 49.
Item 11.
Lordship, as per respondent number 6, Lordship, some local people objected as there is a school near the stop, Lordship, 141 meter away. But this is telephonic instruction, Lordship.
No. You see, if I've understood this, what you call, I don't really completely read it. I read here and there and form an overview. From the cost title, it appears that he has a online license. He just wants a trade license. So in a trade license, issuance of trade license, do you have those restrictions of 100 meters from the school or 200 meters from a pan dukan or 300 meters from a shoe store? Are there restrictions like that?
Already renewal has been done by the excise department, BTC authority.
Pardon me?
Already renewal has been done also. Renewal of his
Has been done.
has been done, but only Lordship.
Excise license.
Excise
That
license.
is done.
Renewal.
Now it is trade license.
Trade license.
Trade license. So Lordship, as far as said, that is said by him, and he made party by name also, respondent number 7. They didn't have a those. These are the Lordship. In the meantime, I still want to take instruction, written instruction, Lordship. Respondent number 6 and 7 is the same person. 7 is by name.
This village council development committee gives the trade license.
He has to give no objection for trade license.
He has to give no objection.
No objection from trade
Under
license.
which law?
Earlier, my trade license used to, CCBC chairman used to issue the trade license. I have annexed the earlier trade license at page 20.
No, this trade, page 20.
Yes, page 20 was the earlier trade license, issued by the chairman, VCDC. It was.
What is VCDC?
Village development.
Village Council Development Committee.
Village Council Development Committee. It was.
Now
built up to by-
this village council is established under which act? Just shows this municipal, Assam Municipal Act.
The agreement they have.
Hmm?
Only as per the agreement, but otherwise in the municipal.
No, you see, because what with my limited understanding, what do you call, under the Assam Municipal Act,
There is
no, there is a provision for granting of license for trade license and callings under 180. Under the Assam Municipal Act, also there is an empowerment to the municipalities to issue a trade license.
there.
But VCLC, does it have that requirement?
CBC, Assam Municipal.
I think Lordship,
It's under their.
BTC accord.
VCC Accord,
BTC accord.
BTC Accord.
Otherwise, the municipal act, there is no problem.
No, in Accord, you see, all said and done, an accord must be followed by an act.
Those cannot avoid it. That is.
Yes, definitely.
The act has been drafted, my lord. It's sent to the governor. So the Bodoland welfare.
No, my difficulty is that
It is-
when I,
He has to receive
no, not that. You see, Article 265 says there shall be no tax without in accordance with law. Only 7 or 9 words. What happens to the constitutional right? no taxes otherwise in accordance with law. You give him the constitution to Mr. Rava, Constitution of India, 265.
Remember.
265. And otherwise, under 19, there is freedom of everyone to do business, whatever he wants. If you are putting fetters to restrain right of a person to do business, you have to show that. Because Mr. Rava, it's a very strange world. When somebody goes and sit down in the footpath, you say that he's a vendor and you permit him. If somebody opens up a shop, then you need so many licenses. Is it not strange? And you are making people compete with those people who don't have a license, who don't have any establishment, who doesn't have a GST registration. You are allowing them to flourish. Is it not strange?
So far as the CDC is concerned, matter, the law has yet to be receiving our assembly.
But then we'll have to say that unless you show the authority of law, then till then, the requirement of a trade license will not be insisted upon. You see, you have, Mr. Rava, there's two options. Number one, tomorrow is the working day. You renew his trade license by tomorrow, end of the matter. Otherwise, my order will become operative if this license is not renewed, then you will have no power to collect any trade license. I'll pass a conditional order. If you renew this, end of the matter, Mr. Kalita will not pursue it. And if you can't show the letter of authority, the power of authority, then we'll have to say that henceforth no trade license.
I need to take instruction.
But this is at the town committee. I said under the Assam Municipal Act there is empowerment. No, you are absolutely fair. You are absolutely fair. So I'm passing an interim, what you call, order to that effect that if by tomorrow is trade license renewed, then this interim order will not be effective. Otherwise, by this interim order, no trade license business. That has to stop. Because Mr. Rava, in the morning you were not there. In the morning, I made two offers. Number one, either you work or we'll give you space. We have some space outside the court boundary. We'll ask you to come with table and chair, sit down and do work here. Because if your officers don't work, so people for trade license have started coming to the court. It's height of what you call lawlessness. How it can be tolerated? And I'm being subjected to overwork. Every day from 6:30 in the morning, my day ends at 12 in the night. Not one day. 7 days a week, 365 days a year.
I'll leave it to your lord.
If you start entertaining rate petitions, encourage people to not work and allow citizens to come to court for renewal of trade license, renewal of X license, Y license, then it is better that I call all the departments here, make them work in my vicinity. At 1:15, I can come out for lunch. Have my lunch in 10 minutes, visit all the tables in 10 minutes. Do my other meetings and all in other next 10 minutes. And at 2 o'clock, I am free to work here. Don't compel me to tell all this. Heard Mr. N.K. Kalita, counsel for the petitioner. Also heard Ms. R.B. Bora, learned standing counsel for the, we record Mr. Rava, your name or Ms.
I'm not interested in it.
Okay, Ms. R.B. Bora, learned standing counsel for the BTC. Appearing for respondent numbers 4, 5, and 6.
Five is actually written as Borpeta. Borpeta normally would not represent it. It should be. I think,
Govardhana,
Baksa. Baksa.
But I am also confused when I did that is because it is a town, Borpeta Road town, man. Borpeta Road town comes under Borpeta. That is why I have written Borpeta. Borpeta Road town, man.
if it is Govardhana, then it is Barpeta.
Then I cannot represent.
Oh, then not for 5. Okay, right.
Actually, I think it should be Govardhana Development Block Baksa.
Govardhana Development Block Baksa.
I think Lordship.
Okay, maybe you are right.
Clarify.
Oh, okay, we will omit that. You will be for 4.
4 and 6.
No, 6 also will not be there then. Oh, this is Baksa.
This is Baksa.
Okay. 4 and 6. So it appears that there is an error in the typing error in the cost title in respect of respondent number 5. So the learned counsel for the petitioner shall examine and do the needful. And if correction of the cost title is required, the same can be done in the concerned writ petition pending section. Next paragraph. Also, just add there for excise will be there, and Mr. R. R. Gugoi, and standing counsel for the excise department appearing for respondent number 1 and 2, and Mr. K. Gugoi, and government advocate, additional senior government advocate appearing for respondent number 3. Next paragraph. Agreed by the non-renewal of the trade license of the petitioner's IMFL on shop.
Now, my lord, it is off shop.
It's an off shop under the name and style of Bholanath, BHOLANATH, IMFL off shop, which has expired on
But expired on 4/2/23.
4/2/2023, the petitioner has approached this court by filing this repetition under Article 226 of the Constitution of India by alleging that the respondent authorities are demanding huge amount of money for issuance of NOC for renewal of trade license. Stop. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on Granite State and Department Council in course of the day. It is called BTC or BTR? BTC. Your BTC website doesn't reflect this organization. Your website of BTC, does not reflect this organization.
CDC, my lord.
Hmm.
As I said, my lord.
No, it's okay. I'm not on that. I'm not disputing what you are saying. There is an organization. There's no doubt about it. And that is approved by the BTC. That is also, it shows. But the VCDC organization itself does not show as a part of BTC right now in the website. It's not shown as a part of the government organization for the time being.
Going on an ad hoc basis.
No, it's okay. I'm just trying to see the legitimacy. When I'm referring to Article 265, I have to be cautious when I'm trading on that aspect. So that's why page is not opening.
I am told that it is alternative to the village panchayat. Alternative to the village panchayat, I am told.
It can't be because it will be under the Panchayat Act, Assam Panchayat Act. In Panchayat Act, there will be an amendment brought to exclude some areas from Panchayat. At least that has not come to my notice. But I don't read daily Panchayat Act.
The act itself, it is excluded, man.
Huh?
Panchayat Raj is excluded
From the draft. In the draft, Panchayat is excluded.
Constitutional amendment 2003.
In respect of VCDC.
No, my lord. Panchayat.
Huh?
Panchayat Raj
Is excluded there.
excluded.
Okay. So therefore, this is an alternative mechanism.
Alternative mechanism, but it's going on in ad hoc basis.
Okay.
Law is yet to be receiving.
Okay. Now I get it. Okay. I was not knowing about the panchayat. That is why those questions. When now it is pointed out, then I can understand. Okay. Hmm. Then I'm changing the nature of my order. You should notice returnable in 4 weeks. requisite extra copies of the writ petition be served on the London State and Departmental Council in course of the day. As it appears that the petitioner shall take steps within 2 days for service of notice on the respondent number 7 by registered post with AD. 7 and 8 by registered post with AD. Next paragraph. Having considered the projection that the petitioner had you had applied. The petitioner has applied for renewal of his trade license. Where is the trade license?
Well, the trade license is 20, madam.
20.
20. Highlight trade license. Because
Trade license. Bearing license number. What is it?
licensee number, madam.
Licensee number. No, this is not license. It should be license, not licensee. License number. What is that?
It is written as licensee number, madam. That is why.
Oh, acha. Licensee number.
Top, madam.
Yes, yes. What is it?
Madam, UHVCD
UH
VCDC
113 dated 5/2/2020 under form number 0113, which was valid from 5/2/2020 to 4/2/2023. Petitioner applied for renewal, huh?
Which is license number?
License number, sir.
License number.
License number.
Yes.
License number, not licensee. License number so and so. Comma, as an interim measure and till further orders, it is provided that that till further orders, the respondent authorities are restrained from interfering with the business of the petitioner without the leave of the court, merely because of lack of renewal of the trade license. Next paragraph, the petitioner shall serve a certified copy of this order on the respondent number. Respondent number 5. To bring the order to the notice of the said authority. In the meanwhile, the London Standing Council for BTC shall also serve to send a downloaded copy of the order to the BDO, Govardhana Block Development Office. No, she doesn't appear for 4, 5.
5 and 6.
I'm a paper for and
No, this is
5 is to rectify by correct by him.
this chairman village council. You are not appearing.
Appearing.
You are appearing for 6. Huh?
6.
Okay, shall communicate this the copy of this order, download copy of the order to respondent number 6 to bring the order to the notice of this said authority. Okay. This is because of Mr. Lava's intervention. When he said that law is what do you call it? It's sent for approval. But then when village council, the village panchayat is not there, revenue considerations of the BTC will come on. That's right.
Item
49. Yes.
Yeah, application has been considered and matter after so much notice matter and hearing matter that has been cancelled, ma'am.
No, cancellation is not an issue. This is not we want. This is impugned here.
No, madam, this is not impugned, madam. Suspension order is impugned, madam.
Huh.
Yes. Against this
No, but
suspension order, madam.
against the suspension order, he has gone in appeal.
No, madam. He.
Just a moment. Just a moment. Okay, give a copy to him, then we'll have to close it and you'll have to challenge this order then.
Yes,
Okay,
against his case.
no, it's okay, it's okay. Mr. I. Alam, learned counsel for the petitioners. First of, Mr. M. Chetiya, learned government advocate, has produced a copy of order under memo number 81. So and so dated 6/11/2023, by virtue of which the retail license under clause 3 of the Assam Public Distribution of Articles Order 1982, has been cancelled. Full stop. Accordingly, it appears that this writ petition has become infructuous, and therefore this writ petition stands closed, with liberty to the petitioner to approach the court again, if so advised, to assail the hearing before referred order dated 6/11/2023, a copy of which has been served on the learned counsel for the petitioner. Okay.
Only thing is that I have approved for your lordship that 90 days have already over. 15/6/2023, my license, my license.
No, but this is Assam Articles Order,
Deputy Order 1982.
1982. You see, the consequences of delay is not prescribed.
That's there.
So even if it is delayed, well, if in the act, in the order it was there somehow that non-compliance would restore your license or some effect. I don't know, but if in that point you want to address me, I may not close it. If you.
In fact, my lord, it may be pending, my lord. During pendency, they have, my lord, 6/11, my lord, and I have filed the writ petition, my lord, prior to this.
Within 90 days, my lord, if suppose notice was, my lord.
And on
issued,
6th, my lord, the
and action has been taken, my lord, then in that case,
No,
my lord.
it's okay.
that
Because
petition is listed, my lord, on 6/11, my lord, but in the bench 5, my lord, at court number 14, my lord. So it posted against my lord today. Wrongly listed, my lord. And order is also there.
You were only one order is passed. Now it is.
no, it's okay, but this issue of the consequences of not passing an order within 90 days, I'm not aware if there is any adjudication on the point. To my understanding, this has become infructuous. If he wants to argue the matter, no issue, will take it up.
In that case, your lordship already granted me liberty, my lord.
It's okay. Hold on, we'll close it. Okay. Okay.
Obliged.
Item 16 with 17.
Yes.
Matter relates to non-payment of contractual dues. Now, what has happened here, Lordship, the petitioner had earlier filed a petition. And the order passed your Lordship in see page 52.
Item,
Item 16.
just a moment.
Yes.
Page
Page 52.
50.
This work was carried out by the petitioner sometime in 2005. And since he has not received the payments, he approached this honorable court by WPC 3131 of 2012. And the honorable court, Lordship, page 53. In the middle portion. Mr. Rahman, learned State Council, as well as Mr. Saikya, learned Standing Council PWD, appearing for the respondents. On the other hand, have submitted that the claim of the petitioner would be verified. And if any amount is found to be due and payable, the necessary follow-up action is taken. The judgment and order passed by this court in Samshirali. So and so would be taken by this lordship, they will determine and later on lordship, the Samshirali lordship, whatever dues are there, lordship, gradually it has to be released. With respect to this order, lordship, I take your lordship to page 60. My dues were quantified at 16 lakhs 13,625. That was on 10/7/2013. Then after the amount being quantified, they did not release. Therefore, I came in contact and the honorable court has given them further 6 months time to comply with the order. After that, I have been pursuing the authority lordship in spite of those persuasions lordship, nothing has been taken. Some of my cases. As on that lordship, nothing else. And they are putting it on one department on the other. Now the burden has been shifted to the GAD. Although this amount has been quantified by the PWD.
Yes.
I make a claim lordship that this amount may be released and I'm claiming an interest of 9%. This is from 2005 lordship.
Yes.
I'm appealing for my lord, respond number 5 matter. We have filed affidavit. Proceed, look into paragraph 4 of our affidavit.
Yes, you use.
Yes. Finance.
As far as the work is concerned, my lord, PWD is not the authority, my lord, who is otherwise allocated. We will only supervise it, being the, my lord, technical department. Funds and all, my lord, will have to be, my lord, concerned authority who has ordered, my lord, for the construction. Even in, my lord, cases of medical college, the construction, it is done by PWD, but funds come from the health, same. Though it is the same government.
Here lordship, the GAT has also been made the party. Since the
It is okay.
Otherwise, my lord, I can appeal.
No, we can do another thing. We can give him all police and ministerial power under Article 226. So he can take few people, raid office here, office 1, office 2, office 3, arrest people and realize his money. We'll give him some powers. Otherwise, you see, how will a citizen know that who is to pay money? He has been ordered to do work for this Independence Day celebration.
But
He has done it.
Part of the
Whatever work, for whatever you have assessed 16 lakh rupees, he has done that work. Correct.
the 78.
Now, if,
Out of the 78 lakh, work order was for 78 lakh. He has completed the part of the work amount.
it's okay, it's okay. But if he has to unearth something more, either will say that the CBI will assist him.
My lord, just only, my lord, I want to point out, my lord, page 23, my lord, of the rule of the Cardiolum Autonomous Council.
No, that is okay. I'm not saying anything to you.
But my lord,
But-
just only point that the deputy commissioner wrote to the government that the funds should be released directly to the deputy commissioner, not to the Cardiolum Autonomous Council. So I'm not at all, my lord.
It's
in
okay.
this moment, my lord, that is my sufficient.
My lord, people perhaps only short date, that this, from the CAG, I can have the instruction whether, my lord, pursuant to the proposal, anything has been released to the deputy commissioner. Very short date, my lord, 3 days will be enough.
No, now we'll direct that you see, authorities will never pay. 2005, we are in 2023. We'll say that the state will pay him, deputy commissioner will pay him, and have this money recovered from whatever authority he wants, if required by arresting people. If the deputy commissioner has to arrest in Bakijai proceeding the chief secretary, he will do it. First writ petition, then contempt, extension of time. Now you say you want to unearth the authority. Now you say that the deputy commissioner, by whatever fund he has in his custody, whatever fund, whatever head he has funds, he will pay payment to him and institute Bakijai proceeding against all others, have them arrested, have the money realized on Wednesday. But I'll write something in the order, some sarcastic. Wednesday, okay. Because you see, this my sarcastic comment will enable you to get the.
No, I will continue.
Convey. Or you show him the video of the proceedings. Then the deputy commissioner will realize by drawing up Bakijai against the government.
But he will be, I will leave it from the CAG. The authority will have to provide the part.
Okay.
From one.
Okay. Mr. RKD
Yes.
Chaudhary, Learning Counsel for the petitioner is present. Just saying the same line, Mr. J. Sutia, Learning Standing Counsel for KAC, and Mr. M. Shidya, Learning Government Advocate are present. Mr. B, on the prayer, made by Mr. B. Gogoi, Learning Standing Counsel for GAD. The matter stands adjourned to enable him to obtain instructions. This on 29. Sorry. We'll give you some more time. We'll make it 29th November. You get sufficient time.
But I'm okay.
29/11/2023. Because you can also tell them. In fact, yesterday or day before yesterday, I forgot. I don't keep a track. In one of the matters, I've issued a notice for interest. You were there? Day before yesterday? No. Yesterday or day before yesterday, I issued a notice. I think you can ask Mr. Upadhyay for irrigation department. For irrigation department, I issued a notice where I have said that I have said why the party should not be entitled to interest. If you can get a copy of that order, I have spelled out my mind why the requirement of interest is there. Again, no, I don't remember. I just keep a.
Why there is a two class in the same category of.
Oh yes. That one. You just get that order and send along with. And then Upadhyay will know. I will not remember it.
Was there.
Huh.
So indicated why there is a distinction between same and why two class is created. That part Roshi says.
I know. Don't want to say it again. You can explain it to him privately. I don't want to give ideas to others.
Item 18 with 19.
I'm waiting for response number 2, 3, and 4. The supposed to file the affidavit in opposition. I've already obtained instruction in the ready, Your Lordship. By next week, I'll file it. In 1 week, I think.
But if you don't file, what will you do?
By next week, I'll file it.
No, that's okay. But what happens if your authorities can't? I don't question. I'm not questioning you.
I've already filed it.
You have everything. Okay.
Interim protection complete.
Huh?
Interim protection is complete.
Both sides are represented. Mr. P.K. Sharma, counsel for the ATDC, submit that he has received instructions and will be filing affidavit in opposition within a week's time. First of all, reluctantly, the matter stands adjourned as a last opportunity to the respondents to file affidavit in opposition in the matter. Most of the respondents are put to notice that in the event no affidavit in opposition is filed within the time allowed, the court may invoke the doctrine of non-traverse and presume that the respondents have admitted the claim of the petitioner and pass appropriate orders on the next date. Next para. List on 1/12/2023, interim order passed in stands extended till the next date of listing.
Item 20.
This is Saikia's matter. This is Saikia. Your matter.
Ultimately.
Nothing we are reporting. Yes. What is this matter?
Hearing number dated passed by the executive officer of the Sonari Municipal Board.
Passed by the?
Passed by the executive officer of the Sonari Municipal Board.
Have you filed your affidavit in reply? No. Okay, on the prayer made by Lanka, on the prayer made by Miss. Your name? P. Ghosh, counsel for the petitioner. Matter stands adjourned today. Mr. K. Gogoi, counsel for the additional senior government advocate is present. List after 2 weeks.
Mm-hmm. 21.
Bolero pickup van was utilized by the police department. On last occasion, was admitted to file evidence, but no evidence was filed.
Okay, instructions received, Lordship. One draft is also prepared by one of my colleagues. So Lordship has picked up the quick dinner.
Non-payment of bill.
Lordship.
Okay. Mr. R. Chaudhary, counsel for the petitioner, is present. On the prayer made by Mr. K. Gogoi and additional senior government advocate, matter is adjourned. There is a last chance to file affidavit in opposition in the matter. So it is made clear that if affidavit in opposition is not filed, in this case, the court shall presume, court shall invoke the doctrine of non-traverse and presume that the respondents have admitted the claim of the petitioner and appropriate orders will be passed on the next date. Next list after this on 1/12/2023. 1/12.
Yes.
Present
22. Yes, ex gratia.
SP has had the evidence, paragraph 4, of article 9. It's admitted as well the incident has occurred in the flat water. So whether the petitioner is entitled the compensation under the notice. Case 59 front of line number 4.
Where is the scheme?
Ballot address 17. Correct. In the bottom ballot 17. The SDRF shall be used only for meeting the expenditure for providing immediate relief.
Page 17.
Yes, madam. 1 second.
Serial number 3.
3 madam. Photo. Flat. That is included. And the quantum.
Where is the police report?
This report, my lord, the affidavit itself, my lord, page 59 of the affidavit, my lord. Fifty-nine.
But then, Mr. Gogoi will have to call this Superintendent of Police to court.
And one of the report, my lord, I have an.
He has to be personally present.
Page 54. Page 54, my lord.
No, 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 I'm now addressing Mr. Gogoi. Mr. Gogoi, see page 59, paragraph 5, the affidavit of the Superintendent of Police, internal page 3, paragraph 5. Read that paragraph.
There were two police reports.
But he is withholding that report from the court. He has not annexed those police reports. He is a Superintendent of Police. So you would have to call him.
So Lordship,
I have the next this report, my lord.
Lordship may give some time.
No, no, he says that he has annexed it. Where is that?
I am
I
not
have
a file,
annexed, my
Lordship.
No, it's okay.
My
Where
lord,
is 57, 15.7,
15/7 plus 52.
50,
15/7, 2020,
page
page 52.
52.
And another report, my lord, page 52. Page 54. I have the next one, lord. Both are written.
You have the original copy of this report?
I have report is there. Page
Submitted for the
page here. They have annexed the
No, no, no.
original one.
I want to see if he has the original one.
Lordship.
there are stories.
So my lord may direct us to produce the dead.
No, no, let me understand.
Then Lordship.
Let me understand. No, that won't be required because this statement is made in paragraph 7 of the writ petition, which is admitted at paragraph 5.
Lordship.
So there's an admission.
Lordship.
Then we direct the authorities to make payment of the this compensation. For Mr. M. Hussain, counsel for the petitioner, also heard Mr. A. Google, an additional senior government advocate, appearing for
Lordship, I am for
respond number.
one,
Okay.
2, 4, Lordship.
1.
5, 6, 7, and 8, Lordship.
No, you just say my senior government advocate has responded
Fine.
2,
Lordship.
4. No, sorry, 2, 5, 6, 7, 8. And he also appears as CGC for respond number 1. Correct?
Lordship.
And Mr. J. Handick, Leonard, standing us for the Revenue and Disaster Management Department, respond number 3. Mr. Gogoi,
4, Lordship. What else?
4 is finance. Okay. Mr. B. Gogoi, standing us for the respond number 4. Mr. Gogoi, it would be okay if you have both as government advocate and
My
CGC.
friend is here, so Lordship may.
For CGC, huh? Okay. Respond number 1, Mr. S.S. Roy, CGC for respond number 1. Next para. The petitioner projects that is sun. That is sun. That on 5/7/2020 at about 3 p.m. the son of the petitioner was playing in the courtyard of the house, had drowned in the Tipkai, Tipkai river near the house of the petitioner. After flood water surrounded the house of the petitioner. So at the time of death, the son of the petitioner was 2 years old. Later on, the dead body was recovered from the flood water with the help of local people and taken to civil hospital Dhubri, where he was declared dead. In this connection, Athani ATHANI OPGDE number 73 of 73 dated 5/7/2020 was registered. The petitioner relies on the police report dated 15/7/2020 and 17/5/2021 by the officer in charge of Athani police outpost regarding the death of the petitioner in due to flood. The petitioner projects that as per the notification number, page 29, number 32, so and so, first line, issued by the Government of India, Ministry of Home Affairs, Disaster Management Department. No, not this. What was the page?
It's
17.
17.
Notification at page 17. Number so and so dated 27/7/2011, comma, State Disaster Response Fund is permitted to be used for granting immediate relief to the victims of flood. And it is projected that the relief amount has been increased to rupees 4 lakh.
Yes, well, it's 30.
Where is that 4 lakh?
Just 32 of my those.
32.
Revenues of this is possible.
Revised to 4 lakh wide. MHA letter number, page 32, so and so dated so and so. As the relief has not been granted to the petitioner, the present petition has been filed under Article 226 of the Constitution of India. Next para. Except for the Superintendent of Police Dhubri, respondent number 7, no other respondents have filed their affidavit in opposition. And it appears that in paragraph 5 of the said of the affidavit in opposition filed by the respondent number 7, the Superintendent of Police Dhubri has admitted the police report issued on 15/7/2020 and 17/5/2021 referred herein before. Full stop. Therefore, as the death of the son of the petitioner is admitted by the respondent number 7, in view of non-finding of affidavit in opposition by the other respondents, the court is inclined to take recourse to the doctrine of non-traverse and presume that the respondents have all admitted the death of the son of the petitioner by drowning, as mentioned herein before. First, accordingly, the court finds the petitioner to be entitled to be paid the relief of ₹4 lakh in terms of the herein before referred notification number 27/7/2011, read with herein before referred letter dated 8/4/2015. So not 30 to make it 29. 29. Same letter. What 32 is for 32? Issued by the Government of India, Ministry of Home Affairs, Disaster Management Division. Who is the disbursing authority under this?
Let's say disbursed by the deputy commissioner.
Poster.
Losses indicate the respondent on authority because deputy commissioner has to send the losses revenue and register management department. So losses may indicate the respondent authority.
Respondents.
No. Again, you see, if I don't give responsibility, then again contempt. Now again, all the departments will say that I am to pay, he is to pay, they is to pay. We have seen Mr. R.K.D. Chaudhary.
Deputy commissioner has only sent the proposal. The
No,
proposal will be
I understand. But there must be some, you see, unless we have just heard Mr. Chaudhary.
3, 4, 5, 3, 4 and 5 losses.
3, 4 and 5.
Court is inclined to direct the Commissioner Secretary to the Government of Assam, Revenue within bracket, Relief and Rehabilitation bracket close, and Disaster Management Department. Respondent number 3, Commissioner Secretary to the Government of Assam, Finance Department within bracket respondent number 4, and the Deputy Commissioner Dhubri within bracket respondent number 5.
Now, my lord, it is district commissioner.
Oh, District Commissioner, no. District Commissioner. Respondent number 5. Jointly and civilly to do the needful so as to disburse the relief amount to the petitioner within the outer period of 4 months from today. So the petitioner shall serve a certified copy of this order before the District Commissioner Dhubri so as to enable the said authority to send a proposal to the competent authority for release of funds. Item?
Item 34.
Yes, your item 34.
I see. Take a good item 42.
Relating to my Ministry of Environment, building permission.
Master Mr. Nayak is appearing, I have to confirm.
You have asked him to be here? You have asked him to be here?
Yes, my lord, because my company, I am one of the director of the company. Actually, petitioner in person.
Just wait for some time. Let him come. Okay, after some time. This is item 23.
In this case, lordship, the petitioner is the registrant society.
Malor, one affidavit is in file, Malor. Another affidavit on behalf of respondent of service, Malor, prepare Malor. Filing Malor.
Lordship, the private respondent, I have sought notice lordship, their name appeared. They have not filed any affidavit also.
Just-
Private respondent. This lordship, other notice of Sevastrom, is the Sevastrom,
Just a moment. Yes. You are asking for adjournment for whom? On whose behalf?
Respondent number 5, Malor.
Who is respondent number 5?
Executive magistrate, Malor.
Notice issued in 2022. He has passed the order. Why is he concerned to file an affidavit?
Lordships, we have filed affidavit in on behalf of the
Or?
registered.
On behalf of?
On behalf of the registered societies, we have filed already. Yeah, another affidavit, lordship, we have prepared in the same date, but lordship, it is, this communication, it was not sent. lordship.
That is by
Otherwise,
whom?
Respondent number 2 already filed, lordship. And in respect of respondent number 5, lordship, we have prepared the affidavit and they have also sent the lordship instruction in on time, lordship. But from lordship, due to some
No, you see, let me understand. Whatever your instructions are, is the executive magistrate empowered to poke his nose in the affairs of a society? He does not have.
immediately, lordship, we cannot. Otherwise, if from law and order situation, they have to have results, lordship. Immediately, that powers not to us, lordship.
Okay.
But when law and order.
So now we'll ask the executive magistrate, we'll give him a notice. Why he should not be made to pay a compensation of 1 lakh rupees to the petitioner, which will be recovered from his own pocket.
That part, lordship, may consider next that I will bring it to the court, lordship, that this is the lordship.
No, you see, he has used his power.
Lordship. Yes, acted lordship due to the from lordship, law and order situation, that's why he's acted to take the lordship. Otherwise, lordship,
No, law and order situation, you arrest the person, take him to custody. If he's disturbing law and order, you drop 107 proceeding.
was the administration of a lordship, that part we cannot interfere. Even lordship, the Pambodar case is also pending same issue, lordship.
Where is the impugned order?
Page 30, lordship, and extra 7. While issuing notice, that order was stayed, but.
Page?
Page 30, lordship.
30. This has been stayed.
It was stayed. In spite of lordship, that stay orders, the complainants entered into the lordship mandir. They entered into the mandir and they have taken lordship possession of the entire Sebastopol. Thereafter, we filed an IA lordship, taking a direction. That IA was rejected only on the basis that 22/12/2022, that IA was dismissed lordship. IA civil number 3398. That the reliefs claimed in the IA is in the nature of final relief. So that IA was.
What is that IA? What is the prayer?
3398.
No, what is the prayer? Just tell us.
After hearing the parties, be pleased.
No, what is the prayer in that IA?
Lordship, that is, after hearing the parties, be pleased to direct the respondent authorities, more particularly the respondent numbers 3 to 5, to immediately hand over the possession of the mandir to its governing body by removing all such obstructions, particularly by removing the illegal occupation of the miscreants over the mandir and or pass such further order or orders. That was rejected. Thereafter, we filed an implement application. In implement, notice was issued. They did not appear lordship. Thereafter, court implemented all the private respondents lordship. Now, causally shown the name of advocates representing private respondents. In spite of that lordship, they did not appear lordship. Taking the benefit of that impugn ordered lordship, they entered into the Sebastopol lordship. All the materials were under their protection lordship now. We lost FIR, police is also not doing anything.
Oh, okay. R. Chaudhary, counsel for the petitioner, and Mr. K. Govil, additional senior government advocate appearing for the respondents on the prayer made by learned additional senior government advocate for the matter. John is adjourned. As a last chance to enable the state respondents other than respondent number 2 to file affidavit in opposition in the matter.
So, SOR 2 already filed.
No, that's why, except that I'm allowing you. So the respondent 2 has already filed affidavit in opposition in the matter. To stop. Although the name of the private respondents are reflected in the cause list, but none appears on call for the respondent numbers 6 to 18. And no prayer for adjournment is made to file affidavit in opposition in the matter. To stop. Time is granted to the state respondents to file affidavit in opposition positively by 24/11/2023, 11/2023. To stop. It is made clear that before this stop listing, it is provided that in the event no affidavit in opposition is filed by the respondents, the court would presume that the respondents have admitted, shall invoke the doctrine of non-traverse and presume that the respondents have admitted the claim of the petitioner, and appropriate orders will be passed on the next date. Interim order passed earlier stands extended till further orders.
Item 25, The matter has become infectious matter. The rice was told by.
So, upon instructions, Mr. S. Hawk, counsel for the petitioners, has submitted that by flux of time, the matter has become infructuous. Mr. M. Chetia, government advocate, is present. Matter is dismissed, closed on having been rendered infructuous.
Okay. Twenty-six.
Oh, yes. What has happened now? Is the matter live? It can be closed. Mr. J.U. N.M. Laskar, Learned Counsel for the petitioner, upon instructions submitted, for the time being, the matter has become infructuous. But he seeks liberty to approach the court again if he is summoned to the police station again. Mr. M. Chetia, government advocate, is present. Liberty is paid for his allowed. Matter is closed on having been rendered infructuous.
27. 27.
As per you, it's a bench 5 matter.
This is bench 5 matter. Okay. None appears on call for the petitioners. However, Mr. K. Goel, an additional senior government advocate, submits that this matter pertains to the subject matter of the petition pertains to bench 5. So accordingly, the registry shall examine and place the matter before the appropriate bench.
29.
Respondent 7 has filed their affidavit, Your Lordship, but it was not provided to us, Your Lordship. Respondent 7 has filed their affidavit, but it has not provided to us. Copy has not been served upon us.
Seven, the counsel was here. Mr. Sharma was just sitting here. You could have asked him.
I already informed him, Your Lordship,
Okay, he did not give it to you.
that he gave one copy to the petitioner, not to the respondents.
I'll provide.
Huh?
I have just bring me a copy. I'll give it.
Okay. Ms. P. Das, Learned, just Mr. R. Sinha, counsel for the petitioner, as well as Ms. P. Das, counsel for the respondent number 7 are present. So there are other counsel also. You are for?
I'm for 2.
Miss and Bora, standing counsel for respondent number 1.
3, 4. Five.
I think you'll be appearing for 2 to 5.
Yes, your lordship. Six finance.
Huh?
For taxation department.
Oh, acha. There is Mr. B. Chaudhary, Standing Counsel for the Finance Taxation Department, appearing for respondent number 6.
Yes.
And
2 to 4.
you are there.
For BTC.
Ms. P.
Appearing
Das, Standing Counsel for BTC, respondent was 2 to 4. And who is for 5?
5, your lordship. 5.
5 also. Okay. First off, Ms. P. Das, known as counsel for the petitioner, submits that she had requested the counsel for respondent number 7 for a copy of the affidavit in opposition, which was refused. First of all, the deprecation of the refusal is recorded in this order. The learned counsel for the petition shall provide a copy of the affidavit in opposition of respondent number 7 to the learned counsel for respondent number 2 to 5. First of all, interim order passed earlier stands extended till the next date of listing. List on when?
The lordship, this matters, this is settlement of market. If it is not, this relates to the settlement of market for 1 year on. So 3-4 months have already passed, more than 5 months have passed. If it is not inconvenient for this court, can it give this to the short date, your lordship?
Okay, I'm asking you which date?
Twenty-third, your lordship.
23rd. Oh, that is Thursday, we avoid that. We make it 24th or 22nd whenever you want.
24, your lordship.
24, 11/20/23.
Keep your words.
Item 30.
In this case, we are in same footing. I have to file an affidavit also along with records, right, place on next day.
My lord, respondent number 4 has filed the affidavit matter. Actually,
Mr. In this case, Mr. Sharma is appearing for what you call, on behalf of the fishery. He's a vegetarian. I am adjudicating the matter about fish. I am a vegetarian. Right.
Yesterday, filed a reply, so I have to take exception.
it is a case of defective
Objection
tender, my
is
lord.
there.
Effective tender.
It is an admitted fact also. They have accepted it.
The fact is that, while Bakija certificate, this tender has, is the highest bidder lordship. We have opened it. We have settled him lordship, and he has given around 50 lakhs bank deposit also. And while we have did what, he has given an affidavit and a copy of the application submitted to the deputy commissioner that he has gone for Bakija certificate. So we accept the technical bit, and before opening the financial bit, they have provided us the this Bakija certificate, and he is found to be highest bidder. His bid is lower. In level playing field, if we consider level playing field also, he is the valid bidder.
No, don't point to him. He is not the bidder.
No, he's a settlement.
No, not that. You are pointing out finger to Mr. Bora. He's a learned counsel. He's a learned counsel. You may say private respondent, but don't show finger to him.
He has also filed a reply yesterday.
I'm sorry. I think he may not mind, Lord.
No, the question of minding is something else, but you see, we are dealing with a system where we have to maintain some decorum.
Yes, I'm sorry, Lord.
My lord, their terms and conditions are that if the Bakija certificate is not supplied, then it will be incomplete tender and it will be not accepted. It is their terms and conditions says. And they have admitted it also.
Mr. Sharma, these things are now very troublesome situation. There are judgments and authorities, not only from this court, but also from the Supreme Court, which is mere aberrations here and there, will not make the decision of the tendering authority bad. What do you call? You want us to take up the hearing now?
Because of that, if
I have to
reply yesterday, some.
So reply against reply.
Me, my lord. So that has.
Reply against reply.
No, that is taking instruction for some. An affidavit is required for my tender was accepted.
The government doesn't, is a neutral stand. Why will the government file affidavit?
Because of that, my lord, the deputy commissioner did not.
They have taken their money, they have taken your bank guarantee. Why they will fight? Now you fight.
They have given 45 lakhs guarantee.
No, whatever be. You said 5 minutes ago 50 lakh. Now it's come down to 45.
Around 45 to 50 lakhs.
It's okay.
The highest bidder by the public interest.
Yes, admittedly, yeah, my learned friend's client is the highest bidder.
My lord, highest bidder cannot be the ground of acceptance of an.
But there is the condition also has the power to authority.
It's okay. When do you want select a date?
After this kind of everything.
No, not 2 weeks. You are enjoying the fishery by then.
Yes,
So making it 29th.
Doing the fishery by giving them.
29th. 29th. Reply if any. Both all sides are represented. The Mr. N. Borak, the counsel for the private respondent, seeks some time to obtain instructions on the affidavit in reply filed by the petitioner. Full stop. No, if he doesn't pay, why should I give time?
I'm praying, Lordship. Yeah, I will file affidavit. We along it. I will place record also. On that.
Okay, the learned counsel for the AFDC submits that he would be also filing an affidavit in opposition and produce the records. Full stop. The same may be done at least 2 days prior to the next date of listing, list on 29/11/2023. Full stop.
Item 34.
Yes, Mr. Nayak.
As far as my instruction is concerned, the petitioner has furnished one copy from the revenue officer to the GMD office, Lordship, stating that earlier DUG number and present DUG number is of the same plot of land, Lordship. But so far as GMD is concerned, Lordship,
Land is bounded by one on boundary wall, and earlier permission was given, it was approved by 2011. That was approved by the Harbor Committee of Authority.
last two paragraphs are 11.
Of this report.
Yes, Lord. However, during site inspection of officials of GMDA, as a part of processing of the current planning permit proposal recently, it is found that the present position, the number 162 of the plot falls under eco-friendly hill zone, as per the new cadastral map available with this authority at present. And secondly, Lordly, plot of land is sharing a common boundary with the neighboring state of Meghalaya. That may not be an issue. And during field inspection, it is observed that there is mismatch of position of the plot and available cadastral map of the area, which requires further clarification.
First, electoral peace between my.
Just a moment. You have a better copy of this document?
Lots of in my mobile, it's there, yeah. So I have to print, give you lots of a color printout.
You can just show me the mobile, if you can just open it up. Because I can't read that dark number given here in that,
Yes, sir.
in that map.
Darkened portion is 162 lordship. In the-
162. Okay, then I don't need your mobile.
In the Notun map lordship.
Oh, okay, 162 is that.
That bigger.
Bigger plot.
And in the old map lordship, another darkened portion is there lordship.
Mobile को DC.
No. It's only for that clarification. If 162 is okay then.
In the Puroni map lordship, one dark square type, rectangular type square portion is there lordship. That is dark number 16.
16.
Yes.
It's whole 16 means 160.
Just a moment, just a moment. Where is that impugn order?
Government communication, they have not written any address.
There's no verbal, only verbal communication.
Spending, my lord, because they are also unable to, because earlier that number 16 is not in my lord eco-friendly zone. Now, same that number 163 is my lord, they say that when it is now eco-friendly zone. But my lord, the master plan is of 2009. After that, they have issued the certificate, only my lord, 2011. There are 4 points, my lord, that's along. I do mismatch, but my lord, is only my suspicion.
Apparently, there is a mismatch.
Yes, because my lord, under tag number 16.
No, there is a difference in the what you call in the what do you call the boundary, this boundaries of the land.
Boundaries of the land, my lord, it is with the, I think your lordship has seen the blue 2 towers with Brahmaputra real estate.
No. You show this map. The size plot of this map and the size plot of this map. There's a difference.
There, my lord, from that.
There's a difference in that structure of the land. You see in this map, Mrs. Saikia,
Yes, my lord.
in this map,
I have also got this map, my lord. I have also announced in the additional affidavit. This map.
See the earlier map, lot 16 that lordship, there the boundaries are straight.
yes, that's what I'm showing it to her, but she's not interested to see here.
No, definitely I'm saying, my lord.
I'm showing you here.
Yes,
Just see here, then you'll find. If you look down, you can't see what I'm showing you.
but they have.
So see this.
Yes,
This map has a boundary of this way, but in the map you are holding, the boundary is different. The boundary is straight. This is not a straight boundary. Therefore, clarification has to be there.
This is my lord, I have applied for a fresh map, because 2, 3 maps are already there, and earlier I have submitted the same map. Then my lord, they have that, unless new settlement is given, my lord, they can issue any.
No, but we'll have to give some time to the GMD to make inquiry. There are 2 reasons. Number 1, first, they have been able to demonstrate that it's a eco-sensitive zone. And their initial permission was sought for 1 by G+8. It is eco-sensitive zone, but that is one. Second, they have demonstrated from this report that this boundary of your land touches upon the boundary of state of Meghalaya. And you know what situation, no, but you know the fact, but you know the situation. There is frequent vertical clashes.
Already decision has been taken, my lord, that this part of land, my lord, which belongs to me from Meghalaya, I purchased from Meghalaya, on my lord, registration of the company's name, that has been transferred to my lord, Assam. And soon notification we have verified from the JD department, my lord, soon there will be issued no notification, since my lord, the neighboring areas are settled.
Where is that? Where is that?
Verbally submitted, they, my lord, when we have inquired, because in the TV and newspaper, it has come, my lord, that my area has been, my lord, included by the Honorable Chief Minister and the Chief Minister of Meghalaya in Assam. When we have seen in the newspaper and my lord in TV also news, several times it is published, then we entered from the JD department. Then my lord, the planning department also, my person.
No, but this requires the investigation. We'll have to give them time. I can't dispose of a writ petition like that. Mrs. Saikia, Mrs. Saikia, please try to understand. With those verbal submissions, I can't dispose of a writ petition.
That is not coming on the way, my lord. Meghalaya boundary, why should I go? Because that is measurement, everything boundary is.
What order you want me to pass? What order you want me to pass?
Only limited, my lord, that earlier they have issued that this land, my lord, case 15, that with reference to the subject cited above, and directed to inform the CO, GMDM, my lord, you that decide referred above fields in residential zone as per master plan zoning regulation of Guwahati approved by the government of Assam, by government notification number so and so, read with the Assam Gazette so and so, corrigendum number so and so, so and so. That is updated 7th February 2011. Then again, my lord, they have written a letter to the GMC commissioner. Then again, they have reconfirmed in page 19, my lord, that after verification of new master plan, it is found that zone already mentioned in this office letter, that is zoning certificate number so and so, dated 7/1/2011 is correct. So twice they have issued the certificate, and master plan is prior to that. In the additional affidavit, if your lordship see page, and my land is, my lord, bounded by boundary wall, and my lord, the Brahmaputra realtors is the, my lord, my neighbor. They are also constructing 2 towers, my lord, 14 stories. Why I should be different? Here, my lord, the page 41, my lord, master plan for Guwahati metropolitan area 2025 land use zoning and development control regulation, July 2009. After that, this certificate has been issued.
Which certificate?
That, my lord, the letter, my lord, no certificate, that letter to the, my lord, from GMD to GMC, my lord.
Which page?
Page 15, 1 is 15. That is letter written to us by GMDA, CO GMDA. And another letter at page 19 to the Commissioner, Guwahati Municipal Corporation by Chief Executive Officer. Two things. Thereafter, my lord, I would like to place that, my lord, page 20, your lordship may kindly see that at serial number 8, name Luitpar Builders and Developers Private Limited, decision recommended, page 20, that is of 21/8/2014. What happened, my lord? It was processed and everything was, MOC was also typed, that is at page, my lord, 23. Annexure page 23. The NOC was typed. We have divided the money only it was to be issued, but my lord, the family, my lord, faced, my lord, the difficulty because my husband died during that time. So we don't do anything, my lord, for 1 year. So this has kept pending, and we have take the decision at that time not to construct for going for the apartment. So everything was last occasion only we had to take the NOC, but because of that, at that time we cannot go religiously or otherwise also, we have stopped there, my lord. And thereafter, They have asked us to apply this. Now also this time page 24, we have deposited 3,57,967 rupees. And my lord, I'd like.
What nature of eco-sensitive zone it is? Eco-sensitive one. There are grades of eco-sensitive zone.
Eco-friendly hill zone.
Eco-friendly hill zone. Then what is this page 20? Eco-sensitive? Why?
Page 20, it was recommended my. They have come this time with a new idea. And co-partners.
No, don't tell us that. You see, there are many things you may not want to hear. Since you are a petitioner person, you may not want to hear from the court. But don't, you see, eco-sensitive zone, if it is zone, higher zone,
Yes.
then no construction is permitted. The Supreme Court has demolished, Cochin, that eco-sensitive zone buildings.
Yes. Put the officials of GMC.
No, that's okay. That's why I'm asking him question.
It's a completely plain land. We did not cut, why not a single, your box of land.
We are not concerned whether it is plain, whether it is hilly, whether it is that land.
After that master plan, they have issued the certificate, it's a residential zone. And my lord, common boundary wall, they have constructed two story tower. Promoter, we have the scope after that. We have purchased the land from the same owner, my lord. And that number.
No, that we are not dealing with that party. We are dealing with your application now.
I can definitely, this is a case of discrimination then, my lord.
Then you make him a party. Then you make the other side a party. We'll hear the case of discrimination.
I have not challenged
No,
the
no.
construction or building construction.
No.
Speaking on a different line.
Yes, why it is eco-sensitive zone?
And they have given to us earlier. Now
As per the master plan.
master plan is prior to that letter.
Please, I am asking you, let him respond to my question.
And
If you want to speak for him, go to that side and speak. I will have no objection. You just have to travel this side and speak.
And that is why, Lordship, on last day, one suggestion was given by me, Lordship. Let the revenue department come into the picture, Lordship. And it will be.
No, it is your officers who are now saying two different stands.
Lordship, the maps we are having, it was prepared by the revenue department. These are not our maps.
No, I understand. But that is the scheme of the law.
Yes.
You see, you are part of the government.
Yes.
You take away their part, including yourself. You just have to take a cabinet approval and the revenue department will come to you. Who is stopping you?
No, the map is already there.
I understand, but there will be not two authorities to prepare a map. Either you say that the map of the revenue authorities is correct, or you dispute is that incorrect. If you dispute it incorrect, then the High Court is not the proper forum.
Yes. Lordship, if we are allowed to go by, Lordship, we have to go by these maps only. Unless these maps are under dispute or it has been clarified by the revenue department.
So as per this, you see this document at page 20. Is a part of what? This page 20 is part of what? It's a minutes of meeting of 21/8/2014. That is of what you call GMC. This is para 6.
Page 21 table is there.
The GMC GMD is not filing any affidavit.
It's not yet. This is instruction.
But Mr. Nayak, you can't sail on two boats. If you are affecting the right of a citizen to construct building, you should show some urgency and file your affidavit.
This, in fact, these maps I received today on the start. And the clarification, one letter was issued by the Revenue Authority to the clarifying that both the DAG number, both the plots, both the DAG numbers are of the same plot of land.
No, a plot of land may have hundreds of DAGs.
No,
but-
16 and 162, same plot of land. That is what has been clarified. by
No, you see, when you have seen a cadastral map,
Yes.
they can't be overlapping. DAG number 1 cannot be DAG number 2. So if it's a composite land, a composite land may have 2 DAG or 100 DAG. It is the choice of the government. They will prepare a cadastral map with 100 DAG for a plot of land. It is their choice. If I don't ask for consolidation in an application to convert it into 1 DAG, you may not do it. So therefore, when you say a DAG contains 2, a plot of land contains 2 DAG, doesn't carry a meaning to me.
No, it's earlier one older, this is new one. Got it? So that is what I'm saying. Earlier it was 16, now it is 162.
Okay.
That is what Revenue Department has clarified. It is in respect of the same plot of land.
Okay.
But earlier that same plot was given certificate by the GMC authority as residency. Now it has come under eco-sensitive, eco-friendly.
But how can that happen?
is
It's your record.
Yes.
So why don't you file your affidavit?
Classify and find it.
Because you
In
see,
fact,
you are-
that letter by the Revenue Authority was given.
Because you are restraining the right of Mrs. Saikia to construct a building.
Last time, code have passed the order to file affidavit by 14th of this. Last order, if you lordship kindly see, has ordered to file affidavit by 14th.
No, that's okay, but you see the practical aspect. He has received two. We give you 2 weeks time. You file it by then, otherwise we will take up the matter for hearing. We give it 2 weeks time.
So lordship give me one sense, my lord. Because my lord, this certificate, there are one certificate letter and another is confirmation that this is the residential zone. And my lord, master plan is prior to that. Master plan was.
When any document comes to record showing that it is a eco-sensitive zone, you are not getting an order of the court.
Yes, my lord.
But if we can only say that if it is an eco-sensitive zone, the order of the court would be you demolish our construction. It's not a question of allowing you. We'll ask him to file an affidavit. I'm not hearing you. We'll ask him to file an affidavit. Without that, we can't hear you. And that hearing doesn't give me any, and that hearing doesn't give us anything.
Since April, where my lord, they are confusion, my lord, only creating confusion that tag number 16 is my lord not eco-sensitive zone, but tag number 162 is eco-sensitive. The town plan or he was telling.
You file a suit for compensation. If you are agree with the delay,
Tag number 16.
it's
they said
okay.
not eco-sensitive
It's
zone.
okay, but once
And
it is a
not
eco-sensitive zone,
same tag number.
we don't know about that. We ask them to file an affidavit to bring on record. Because if it is once it comes to the notice of the court, it is eco-sensitive zone. Beyond eco-sensitive zone number 1, there's a ban on any type of.
Whether at the rules and stencil, they can send one time, my lord, it is a residential zone.
We'll
another
decide
time,
that,
my lord,
permit them to file an affidavit.
So master plan is prior to that certificate.
Mr. Saikia, you are being unfair.
Sorry, my lord, with that case. Just submitting my case.
It's not a question of submission. Your submission must give what do you call it? It must be brought to a logical end. I've told you, if it is an eco-sensitive zone, if it's an eco-sensitive zone, you are getting a negative order. If you want to go ahead, I'm ready to pass an order.
Beyond this, my lord, only one thing I'm submitting, the master plan is 2009.
Okay,
Letter was
heard
given-
Mr. Zain Saikia, counsel for the petitioner. From the documents produced by by Mr. P. Nayak, standing counsel for the GMC and GMDA, it appears that while in one set of documents, the the plot of land of the petitioner is stated to be falling within the residential zone. However, in another set of documents, the first set of documents relate to contains reference to land covered by DAG number 16. Full stop. It is projected by the Learned Standing Council for the respondent, the GMDA, that as per the revenue records which they have recently received, the land covered by DAG number 16 is now converted to the land covered by DAG number 162. Full stop. However, as per their records, if the land is covered by DAG number 162, the land falls within the eco-sensitive zone. Full stop. If that be the case, the GMDA would positively file, if that be the case, considering that the right of the petitioner to carry out construction on the land has been infringed, the GMDA authorities shall ensure that affidavit in opposition is positively filed within 2 weeks from today. Is when? Today is 1 week. Okay, within a week from today. Filing of affidavit should be within 24/11/2023. List on 29/11/2023. The bench of documents produced by the Learned Standing Council for the GMD is returned. No. I think for others, we won't have time for taking up matters. Yes, Mr. Das.
30, my lord, has been.
Prior to this, my lord, your lordship.
Please, don't know. That is hearing day. I'm not preserving that day.
Prior to this, your lordship should pass an order. Others may. The famous, my lordship. My item is 32. Let it come up on any other date, madam. I'm paying for a stay order where you're in respect of the others, your lordship has already passed.
30?
Registration of pharmacies, their registrations were cancelled. And
Show me that record. 32.
Page 32. The lordship was in respect of similarly situated person, the lordship.
Health, who is there?
That one.
Here you're there.
That 134.
Which one?
Page 134, your lordship will state that order because the cancellation was done in violation of the principle of nature.
Page 134.
134, your lordship. 134, 136. Paragraph 9. One 35, page 135, your lordship, that personal hearing was not given. Decision that
We provide that this interim order will also cover the case of the petitioner. We don't write so much. Okay. Heard Mr. Binida, Senior Counsel, assisted by Ms. R. Deka, Counsel for the petitioners, as well as Mr. Mr. M. Bhuyan. Okay. M. Bhuyan, and Standing Counsel for the Learned Counsel, appearing on behalf of Mr. B. Gogoi, Standing Counsel for the Health Department. The Learned Senior Counsel for the petitioners have referred to the order dated 17/10/2023, by which interim orders was to be prayer for interim relief was to be considered on the returnable date. First of all, it is pointed out that the pharmacy licensed of the that the petitioners were removed from the role of pharmacist by order dated
11/6/23 and 12/6/23.
11/6/2023 and
12/6/23.
12/6/2023.
Violation of the order dated 31/5, that is at page 85.
In violation of order dated
31/5,
31, 5, 20,
28, 2018.
2018.
18 in WPC 2284 oblique 2015.
In WPC
2284 oblique 2015.
15.
15.
Okay.
By not giving them opportunities of.
By not giving and by not providing them opportunity of hearing. Full stop. It is also pointed out by the learned senior counsel for the petitioners that the nature of interimly sought for has already been granted by this court by order dated 16/6/2023, passed in WPC 3340 of 2023. Full stop. Having heard the submissions made by the learned counsel appearing on behalf of the standing counsel for the health department, court is of the considered opinion that the circumstances under which the facts under which the hearing before referred order 16/6/2023 was passed squarely covers the case of the petitioners. Full stop. Accordingly,
Cancellation.
in view of the in view of above, the operation of the impugn order dated
It is 11/6/23 and 12/6/23.
23 passed by the Assam Pharmacy Council to remove the petitioners from the role of pharmacists shall remain suspended till till further orders. Next, the petitioners shall produce a certified copy of this order before the concerned authority to bring it to the notice of the said authority. List after. You filed your affidavit? Okay. Next, the respondents may file their affidavit in opposition within 4 weeks from today. List after 4 weeks.
Yes. My lord, in item number 38, the interim order is still today. My lord. It's
Okay,
going
interim
exist
order.
now.
Okay.
My lord may also call for the record because notice was.
Item?
Item 38.
38.
Record of the labor, from the labor court.
Okay.
And this for the.
I am for the respondent.
Workman, Indian.
You'll have to call for the records?
Record will
Okay.
be
Okay.
called.
Heard. Mr. S. Chakravarti, counsel for the petitioner, as well as Mr. K. M. Haloy, learned counsel for the respondent number 2. As the order of the Labour Court Guwahati has been, Labour Court Assam has been assailed in this writ petition, let the records of
Reference number 1.
records of reference case number 1/2021 be called from the court of from the Labour Court, Assam. List after 4 weeks awaiting receipt of records.
Interim order.
It was already there.
No, it is still today.
No,
Yes, my lord.
is it?
Paragraph 8.
Having regard to the result that till the okay, interim order passed a distance extended till further orders.
Thank you, Your Lordship. For item number 42 is a contempt case, my lord. Let it come after a week.
43, okay.
42.
42.
Yes.
Okay, yes.
My lord, I would like to mention item number 33, my lord.
30,
33, my lord.
yes.
So can it be listed on a fixed date, my lord, on 27 or 28, my lord?
Just on 23.
The affidavit is supposed to be filed, my lord, from the respondent side, which is not yet filed. my lord.
Who's for PWD?
Item number 50, Lordship, Mr. B. Gogoi was present, my lord,
Okay.
because of the personal difficulty, he had to leave. I was informed that the affidavit will be filed by Monday, my lord.
Will you file by Monday?
Yes, I was informed by Mr. B.
Okay.
So,
Petitioner in person, as well as Mr. B. Gogoi, standing counsel for the PWD are present. So please, learned standing counsel for the PWD has submitted that affidavit in opposition will be filed within the next week. Post on, list on 29/11/2023. Affidavit in opposition shall be filed at least 2 days prior to the next listing. First of the petitioner is a person shall provide his email address to the counsel for the petitioner, through which a soft copy of the same shall be transmitted to him. You give your email address to Mr. Shalia, your email address.
36, intimate is there. I don't know, 36.
36.
Yes.
Okay, intimate extended.
Published.
46 and 47, we take it as an date.
45 and 46. Next week there is difficulty. We can week thereafter.
46 and
29th or 30 or on 1st December, whenever we want. 1st December.
46 and 47.
46 for the 1st December. Yes, Mr. Dubey.
Yeah.
44. You filed your affidavit.
I not, in fact, the deputy commissioner has to file, because the instructions are there, the commissioners, the TC regard compensation. We had 2 containers. Direction has been issued to the deputy commissioner. Last season, time was granted to them to file it.
You have filed your affidavit.
No, I have not, because I am relying on their stand, because I have directed them the guideline that has been there, on basis of which whether they have to pay it, and that's how they have taken time.
Who is appearing for? Who is appearing for?
My friend appears.
Lordship, 2 weeks time is given.
2 weeks to file affidavit. Item number 44. Is a 22 matter.
Yes.
Okay, none appears on call for the, we don't write that because we are late. Both sides are represented. Mr. R. Dubey, counsel for respondent number 2 submits that that he would be relying on the stand taken by the respondent number 1. You're
I represent one, sorry.
you're for 1. Affidavit of respondent number 2. So Miss
Yes, ma'am.
S. Ahmed, counsel for respondent number 2, prays for 2 weeks time to file affidavit in opposition in the matter. Next panel. Both the respondents are put to notice that that this being a contempt proceedings, the respondents have not been exempted from personal appearance. First of therefore, if affidavit in opposition is not filed, the both the respondents shall be personally present. If it is not filed within 29/11/2023, both the respondents shall be personally present at 10:15 a.m. on 1/12/2023. Most of the learned counsel for the respondent numbers 1 and 2 shall transmit a copy of this order to the respondents, which would constitute notice for personal appearance on failure of filing affidavit in opposition in the matter. Transmit this order. It will have consequences. Correct?